चेक। भैया ये वाला माइक चाहिए था। चेक।
morning, everyone. Today is the second day of the SBA Law Conclave and our panel discussion on Supreme Court and judicial activism. A very good morning to everyone, and especially to our esteemed guests. Honorable Justice Vivek Agarwal, sir, our esteemed co-chair, Professor R. Venkat Rao, sir, our distinguished speakers, Dr. Aman Ingorani and Mr. Siddharth Gupta. I request all our esteemed dignitaries to kindly grace the dais. It is a great honor for us to have such an esteemed dais in front of us. I now request Honorable Vice Chancellor Sir Dr. S. Surya Prakash to kindly felicitate our esteemed panelists. Thank you so much, sir. Before we begin with the panel discussion, I would like to introduce the honorable dais to everyone, starting with the chair of the panel today. It is both a privilege and an honor to stand before you today to introduce a jurist whose life and work embody the true spirit of justice, wisdom, and compassion. Honorable Justice Vivek Agrawal, sir, of the Madhya Pradesh High Court. Justice Agrawal hails from Kasganj in Uttar Pradesh and was brought up in the Sihor district of Madhya Pradesh. Justice Agrawal, during his days as an advocate, practiced civil, criminal, and constitution matters at the High Court of Madhya Pradesh. He was elevated to judgeship in the year 2016 and was made permanent judge in the High Court of Madhya Pradesh in the year 2018. Justice Agrawal has also served as a judge of the High Court of Allahabad prior to being transferred back to Madhya Pradesh. Justice Agrawal is a distinguished member of the Executive Council of the National Law Institute University, Bhopal. His lordship is also fondly regarded as a humanitarian judge for his gracious way to deal with the matters brought by the downtrodden members of the society. Justice Agrawal's judgments are seminal and have had a ranging impact in the matters of criminal and constitutional law. It is with great respect and admiration that I invite you all to join me in welcoming Honorable Justice Vivek Agarwal, a judge, a mentor, and a true champion of justice. Moving forward, I would now like to introduce the co-chair of today's panel, Professor Dr. R. Venkat Rao. It is an honor to introduce Professor Dr. R. Venkat Rao, an esteemed academician and legal scholar with over 45 years of teaching and research experience. He currently serves as the Vice Chancellor of the Indian International University of Legal Education and Research, Goa, and has previously held the distinguished position of Vice Chancellor of the National Law School of India University, Bangalore from 2009 to 2019. Professor Rao has made immense contributions to legal education and policy, serving on the statutory bodies of several law schools and holding key positions in institutions such as the Indian Institute of Corporate Affairs, Indian Law Institute, and the Indian Institute of Public Administration. He has also been associated with esteemed organizations like the UPSC, the UGC, the NAC, and the Bar Council of India. A recipient of numerous prestigious awards, including the Professor N.R. Madhava Menon Best Law Teacher Award 2018 and the Attorney General K. Parasaran Award for Outstanding Scholarship, Professor Rao has authored 6 books and over 130 research papers. He has successfully guided 3 LLD and 21 PhD scholars and has represented India on academic and research platforms in over 30 countries. With an unwavering commitment to excellence in legal education, Professor Rao's vision continues to shape the future of legal academia. It is with great respect that we welcome him to share his valuable insights today on this panel. For our first distinguished speaker, I may introduce you to Dr. Aman Hingorani, a distinguished senior advocate and a mediator at the Supreme Court of India, who also serves as an arbitrator of the Delhi International Arbitration Center and other reputed institutions in India and abroad. Dr. Hingorani has been deeply involved in legal education, having taught law students, faculty members, and practitioners for decades. He has contributed as a resource person at the National Judicial Academy, Bhopal, and various state judicial academies. He is also a member of the Executive Council of NUSRL Ranchi and the Board of Mentors for the Masters in Mediation and Conflict Resolution at NLIU, Mumbai. An internationally recognized trainer in advocacy and mediation skills, Dr. Hingorani has played a pivotal role in developing legal curricula, including the Indo-British Project on Advocacy Skills Training, ADR modules, and All India Bar Examination, and mediation rules for leading institutions. His expertise was sought by the Parliamentary Standing Committee on Personnel, Public Grievances, Law and Justice, and many of his recommendations were incorporated into the Mediation Act 2023. Beyond dispute resolution, Dr. Hingorani has gained national and international recognition for his work on the Kashmir issue, having presented expert evidence before the Foreign Affairs Committee of the UK Parliament. Sir also has another association with NLIU as he takes a national course on advocacy, drafting and pleading every year at this university. So we are very happy to welcome Sir back again. Last but not the least, I would like to introduce our second distinguished speaker for today's panel, Mr. Siddharth R. Gupta, who is a graduate of NLIU Bhopal 2006 batch and is practicing at the Supreme Court of India. He also has regular appearances before various high courts across the country. Mr. Gupta began his legal career under the guidance of Mr. Vivek K. Tankha, senior advocate and seasoned parliamentarian. Over the years, he has handled a wide range of matters including real estate, education, taxation, service law, and arbitration. He was also the standing counsel for High Court of Madhya Pradesh establishment for almost 4 years, representing the High Court as a party before various courts. His clientele includes corporates, industries, prominent media groups, and various PSUs. He has had the distinctive feat of representing 9 nationalized PSU banks at one point of time, whilst handling the maximum scale of financial and monetary matters in the High Court of Madhya Pradesh. He shifted his practice entirely from the High Court to Supreme Court in the year 2022, after practicing in the High Court for almost 15 years. Mr. Gupta is also one of the founding members of CAN Foundation, Pan-India initiative dedicated to making legal education and legal profession accessible to the financially challenged candidates undertaking law. We are truly honored to have him here with us today. With that being said, and without further ado, I would now request the Honorable Chair for today's panel to kindly take over and commence the session.
Very good morning to all of you. Today's subject is really interesting, and I am blessed to have a very eminent panel with me. So my work is eased to that extent that I have to only coordinate their activities and not to add anything. But I'll be failing in my duty if I do not set the tone for discussion. That is the subject of the day. The issue is that whether activism is at all required in the judicial working of the courts. I'm not talking of Supreme Court. I'm dealing it on a wider canvas, whether activism is required to, or it is a boon or a bane. I think that will be required to be addressed by our speakers. Second issue is that what are the pros and cons of activism? Third issue is that who are the beneficiaries of the activism of Supreme Court or High Court? Though the topic is restricted to Supreme Court, so our panelists will be talking about Supreme Court judgments, but who are the beneficiaries of this activism? Yesterday, Honorable Chief Guest talked about Oliga Tellis case. Then we have Vishakha case. We have a case of Godavardhan. Then there are several other cases which have now recently there's a controversy in Telangana about the burning of the jungles, whether they can damage the environment to clear the site for development of infrastructure. These all aspects are required to be looked into. Another thing which comes to my mind when we talk of activism is that is there any systemic study to point out that from 1950 till date, how the activism has evolved. We all are aware that PIL is one of the forms of activism, but how it has evolved and how it has helped people of this country, we the people of this country for whom the Constitution is made. Whether there have been change in the tone and tenor of activism with the persons who are in power, and to put it more straight, whether when the executive was too strong and too headstrong, then what was the response of the judiciary, and what was the response of the judiciary when the executive was somewhere weak or was lacking in that majority which may be called a might of the democracy. All these things may be discussed, and the basic theme should be, and I think that my speakers will take care of it, that who is the beneficiary of the activism. Thank you very much. I request Mr. Professor Rao to deliver his, and one more thing, that we are given 90 minutes time. I think that 3 of us should take 10 minutes each, and 5 to 10 minutes for intervention, and then question answer session.
Revered my Lord, Justice Vikram, the chairman of this panel discussion, very distinguished panelists. In fact, I have come here to hear to Hingorani and Siddharth, and I'll be playing just a gubernatorial role of speaking not more than 7 minutes. My distinguished senior colleagues, vice chancellors, my colleagues, and above all, the 21st century hopes of this wonderful Constitution of India and the great country, my young student friends. So Upendra Bakshi in one article says, the Supreme Court of India, believing that those who make peaceful revolutions impossible will make violent revolutions inevitable. The judiciary in India has domesticated revolution through activism, he says. And if you look at the history of the Supreme Court of India, the last 75 years, you would find that it is Supreme Court which has infused life into the otherwise dead letters of the Constitution of India and made the Constitution of India a living document. If today people refer to the Constitution of India as a living document, it is because of the life infused by the Supreme Court. And normally people say the court doesn't have the sword or the purse. But in my opinion, the nascent jurisprudence of Supreme Court of India has been sharp, and the recent jurisprudence of Supreme Court of India has been rich. And the Supreme Court of India, through activism, has made it a common man's activism and not a judicial activism. So Bakshi says, India might have had become a republic in 1950, but the Supreme Court became Republican only in 1970s, thanks to the advent of 3 to 4 brilliant judges, Justice Krishna Iyer, Chinnappa Reddy, Desai, Bhagavati, among others. And Chinnappa Reddy was once telling me that for the first 25 years of the court, it was always concerned more about examining the whys of the decisions of the government. And mostly it was negative in perception. And principles of public law were never enunciated by the Supreme Court in the first 25 years. And we were always looking to the United States Supreme Court, the House of Lords as it was then, and the French administrative courts for principles of public law. But from 75 onwards, right up to 2025, new principles of public law have been enunciated by the Supreme Court in such a way that today the judgments of the Supreme Court of India are treated with awe, admiration, and respect by the Supreme Court of the United States, and now the Supreme Court in the United Kingdom, and the French administrative courts. And therefore, the Supreme Court of India has become the Supreme Court for India. But as the co-chair of the panel, adding the footnote to what the chairperson has said, I would raise 2 issues. Number 1, should it be judicial activism or should it be judicious activism? Can judicial activism border on judicial hyperactivism? The second issue is, what would happen to the sanctity of the doctrine of separation of powers if it is more a question of fault-finding and not fact-finding? Is it the combined responsibility of the legislature, executive, and judiciary to do justice to the common man? Or is it an issue of pointing out fingers at each other? Now, where do we stand? Now, this is a question that is to be answered. Because as Alexander Peckless says, the Supreme Court may be infinitely powerful, but frightfully defenseless. And therefore, if the court continues to arrogate to itself, what would happen? And the Supreme Court, by taking the help of activists, university professors, and other members of society, has contributed to one important thing. Increase in the faith of Constitution has been due to judicial activism. But to what extent can this go? So, thus far and no further, is it the answer? Now, these are some of the issues that are required to be answered by the panelists, and I hope the House will throw luminosity on these particular issues to find out whether activism should be judicial or judicious. I'll be joining you again in the panel discussions, and I'm bound by the caveat of my chairman, therefore I take leave of you. Thank you very much, sir.
What Professor Rao says takes us to the issue of progressive or proactive. Whether judiciary should look for a progressive approach or for a proactive approach. I request Mr. Aman Singorani to take the lines.
The chair, Justice Vivek Agrawal, the co-chair, Professor Rao, my colleague Siddharth, distinguished dignitaries of the dais, friends, students. When the topic of discussion is actually judicial activism more in context of Supreme Court, and when we look back on the functioning of the Supreme Court over the last 75 years, I would actually divide it in 3 phases. The first phase is from 1950 to 1979, when the Supreme Court was functioning more or less on the common law system, adopting the adversarial role, doing adjudication. Within the common law system, as you all are aware, there is positive law school, natural law school. So the Supreme Court started off on a positivist note with the A.K. Gopalan's case, 1950, swung back into the natural law school by Golaknath, 1967, went back midway in Keshwanda Bharati to 6 judges positivist, 6 judges natural law school, Justice Khanna, adopting the natural law school but saying fundamental right to property is not really something beyond amendment in a socialist constitution. Going back to the positivist law school in ADM Jabalpur, 1976. Going back to the natural law school in Maneka Gandhi, 1978. But in all these cases, the court was adjudicating. There was a list, a dispute. The court was functioning complete with the checks and balances of the common law system, both on the judge and the litigant. So the court was bound by pleadings, was bound by properly presented evidence, by the issues. The court had a passive role. Natural law school does not necessarily mean judicial activism. It's a different approach within common law. And that is also, judicial activism also does not mean necessarily juggling for political space. We have seen with the Zamindari laws what had happened. We've seen with Privy Purse what had happened, 1971. So, but it was all within the natural law school. But the point to be mentioned is the court, there were self-imposed restrictions of the common law system on the judge. The judge could not take an active role going around reforming the system, because the court had to decide a matter, had to resolve, decide the conflict. There were checks and balances also on the litigant. Only the aggrieved party could move the court, not any busybody. The person had to present the petition in the proper form, follow the proper procedure. There were doctrines like res judicata, laches, etc. The whole idea was to have a level playing field for both litigants. Then came PIL with under royal prisoners case, Bagul blinding, Rudal Shah, which was a different kind of litigation, where there's no dispute. You can't keep people in jail for years without trial for periods longer than had they been tried, convicted, given maximum sentence. You can't blind people in police custody. You can't keep people in jail after the acquittal. There's nothing for the court to do. There's nothing for the court to decide. There is no list. And this was a remedial jurisprudence. It's not adjudicatory. It's not adversarial. PIL, being a remedial jurisprudence, all the features flow from the remedial nature, relaxation of locus standi. Anybody can move the court on behalf of the members of the public at large who suffer from a disability, whether illiteracy, poverty, ignorance, mental incapacity. But it was a tool for the poor, for those who did not have access to courts. Because it's remedial, anybody could move the court, even send a telex. Because it's remedial, procedural flexibility is there. Because it's remedial, doctrines like res judicata, etc. don't count. Because it's remedial, The court assumes other roles in as adjudicator, becomes a monitor, an administrator, a legislator like in Vishaka, involving in public policy, it gets involved in policy matters, adoption of Indian children by foreigners, Lakshmikant Pandey. You had crime against women cell being set up by virtue of the Supreme Court interventions. So the court got involved in policy, court would legislate, court would assume new roles beyond adjudication, minus the checks and balance of the common law system. And that's a very important point, because every judge has their own value system, has its own thought process, has its own philosophy. In a common law system, there are judicially manageable standards. But in a PIL, it's very much left to the judge to take an active role, go beyond the pleadings, beyond the issues, beyond the evidence, to actually establish the facts, to have fact-finding bodies, to do monitoring, to do administration. Supreme Court ran the Ranchi Mental Hospital. So the court has a much different role than adjudication, minus the checks and balances of the common law system. And similarly, the checks and balances of the common law system of the litigant goes away. You need not be the aggrieved person, which also led to, of course, busybodies coming in, but that's a different situation. We'll come to that. But the point is, in the second phase, where the court expanded its role of judicial review, PIL is not in the Constitution, but Article 32 says, right to move the Supreme Court to protect your fundamental right is guaranteed. It does not say how you can move. It does not say who it can move, or who can move the Supreme Court. I believe Supreme Court was judicially active in accepting the argument of the petitioners that the Article 32 imposes an obligation on the Supreme Court to enforce fundamental rights, regardless of who moves it or how it is moved. It's based on obligations, not on rights. So it's somebody telling the Supreme Court, do your job of protecting fundamental rights. And in the process of protecting fundamental rights, you can legislate, you can interfere in policy decisions, you can give interim relief without even a prima facie case being made out. There's a disconnect between interim relief, the relief, and the right. Those who have studied PIL will know what I'm talking about, the different kind of cases. Olga Tellis was mentioned, a right but no remedy, except a warning before prior eviction. And leprosy patient's case, encroachers, you cannot evict them. They have no right, but there's a remedy. So this is a different jurisprudence. So far, so good. Then came the third phase, where the Supreme Court expanded PIL to citizen standing, governance issues, environment pollution, etc., which could be litigated as class action under Order 108, CPC. Now, this is a third category of cases where there can be a conflict, but what the Supreme Court has done has brought within the ambit of PIL, minus the checks and balances of the common law system, cases which do or can involve a conflict. Doon Valley case, competing conflict between employment, defense, environment. Is the Supreme Court then balancing the competing interests? And that's where I feel maybe the Supreme Court has expanded judicial review beyond the limits of the law. Because here, as I mentioned, there are no checks and balances of the common law system. Every judge will have a subjective opinion. A subjective opinion would mean an arbitrary decision. It's not a question of malafide or a person not knowing the law. The structure itself enables the court to act subjectively. And that's why one bench may give one relief, another bench may not give the same relief. And that's not healthy for the institution. That also takes upon the issue of accountability. What did Madagascar's case say in 1966? Fundamental rights cannot be violated by a judicial decision. We are not state under Article 12 while deciding a case. Very well. I disagree with that. I would rather go with Justice Hidayatullah's opinion that judicial decisions can violate fundamental rights. And that's what Justice Matthew has said in Kishanla Bharti's case. Also in N.M. Thomas' case, 7-bench decision in 1975. And then in Namdev Chauhan in 2010, the Supreme Court said ADM report did violate fundamental rights. But let me assume a fundamental right cannot be violated by a judicial decision. What happens when the court is not adjudicating? When the court is administrating? When the court is legislating? When the court is monitoring? When the court is acting as an ombudsman? Where is the judicial accountability if there's a violation of a fundamental right? So when we talk about judicial activism, of course, the courts have to respond to the needs of society. PIL, in my view, is a symbol of a broken system. The criminal justice system had broken down in the 12 business case. So it was a hard case. The courts had to respond. The courts have to respond to the needs of the people. And so we evolved this new jurisprudence of PIL, which is unique to India in the form it exists here. Other countries use class actions or some permutation combination. Now South Africa, Kenya, etc., have tried to bring PIL into the constitution. It's not really worked there because it worked here for different reasons. That's another debate or another topic of discussion. So it's a new jurisprudence. But in my view, it has been expanded beyond recognition. And in a way, it has been hijacked by middle-class interests, CNG buses, smoking in public places, catching stray cattle. The tool of PIL has been blunted. PIL was created for the poor. PIL was not created for governance issues. The same excellent judgments on environment and governance couldn't be given by the Supreme Court in class actions, complete with the checks and balance on the court and the litigant. There would be no misuse of PIL. But by expanding PIL to such an extent, to jostle for political space, in my view, what has happened is you've had Balwant Chaufel's decision. Now, if anybody wants to file a PIL, the court will see the credentials of the petitioner, will see a prima facie case on the merits of the petition. I see a bonded laborer. I want to go to the court to get him released. Rather than focusing on the court's obligation to protect the fundamental right of the bonded laborer, I have to give my Aadhaar card. I have to explain why I want to file a PIL. I have to say why I have to give security if my case is found to be misconceived. Why would I want to entangle with the state? Why would I file the PIL? PIL started with press reports for Sarah Khatun. Today the court says it has no evidentiary value. Of course it has no evidentiary value in the common law system. But what about a non-common law system? S.P. Gupta's case talked about PIL being a non-Anglo-Saxon jurisprudence. It's in S.P. Gupta in 1981 where the Supreme Court introduced citizen standing. But that very case talked about PIL being non-Anglo-Saxon. So today you go to a court for press reports is thrown out and costs are imposed. So the flexibility of this mechanism, the Supreme Court has passed perhaps the finest decisions of any constitutional court if you see the second phase. PIL as a litigative strategy has given relief to millions of people at their doorstep. The Supreme Court has got its credibility because of PIL, because it has actually managed to give concrete relief to people. But that has become diluted, in my view, by expanding it so widely, which could actually have been litigated as class action, bring it within PIL, so that today nobody files PIL for the poor. People file PIL only for publicity, for ulterior motives, for rivalries. And that, unfortunately, makes us think whether we need to revisit the whole jurisprudence of PIL and also judicial activism, confine judicial review to the appropriate limits of the law, bring in judicially manageable standards by which there's accountability both for the bench and the bar and the public. Because there is a misuse of PIL by lawyers, there's a misuse of PIL by the public, members of the public, but that is because the system permits it. So there needs to be, in my view, a complete overhaul of the structure before we can even talk about, and that's very important because the only institution that has actually worked in this country has been the judiciary. People go to court because there's a faith that we'll get justice. When the executive legislature fails, people go to the court. Courts may not be the best resort. Court can release a bonded labor, but court can't rehabilitate a bonded labor. Court can release some victim of crime, like the blinded in Bhagalpur, who's going to rehabilitate them? It has to be the executive. Courts don't have the sword or the purse. So you need the other organs of the state. So the courts may not be the best resort, maybe not the best forum, but they're the last resort. And it is here where the courts needs to be sensitive to the nature of the cases that come to it. If it's for the if it's for the poor, it's for the marginalized, for the destitute, do away with your legal formalism. If it is citizen standing, bring in the rules if you want to. Right now, we are painting everybody with the same brush. So I'm conscious of my time, so I'll stop here.
Not because of time. I would like to put 2-3 queries to you for the benefit of the audience.
Yes, of course.
One is that Rahul Berger says that there is government by judiciary. Now, what will be your reaction that should courts try to run the government, that is the government by judiciary? That's my first point. Point 2, in Vishakha's case, Supreme Court literally laid down or prepared a draft legislation. Should it be left to the courts or should it be left to the legislature? Third, selective versus proactive. Like, let me expand it in less than a minute. When against the farm laws, there was an agitation. There were, on the one hand, there were rights of the farmers, and on the other hand, there were rights of the passerbys who were using those national highways or the roads. Now, whether there should be some guideline where the activism should come to the forefront and where there should be a restraint so that common man knows that in which situations courts are going to be proactive or add on a head of activism and where they will be having a passive role. Because another example comes to my mind. For the first time in the service jurisprudence, when Shetty Commission's recommendations were adopted and enforced, it was for the first time in the history of service jurisprudence, it came that though the recommendations of pay commission are sacrosanct and they have to be implemented. Whereas prior to that, the view of the Supreme Court itself has been that the recommendations of the pay commissions are the recommendations and they are for the employer to decide how much they can adopt and adapt. So in this background, larger context background, the points which I have raised, I think that you being an eminent speaker and then Professor Rao, if he can give his wisdom.
Well, you see, we don't have a strict separation of powers in this country. You have an insulated judiciary having extensive control over the legislature and executive. The only standard for checking whether the Supreme Court is acting within its powers or outside its powers is the Constitution. The Constitution says Supreme Court is a fundamental right to move the Supreme Court to protect fundamental rights. So if the end is clear, protect fundamental rights. And if that is not being, there's a violation, then in my view, Supreme Court has every power to do whatever is necessary to protect fundamental rights. You mentioned Vishaka, in one of my cases, Agra Mental Asylum, Gwalior Mental Asylum, Supreme Court, after running the hospitals, set up a committee, found it was not good enough, decided to make these hospitals autonomous after legislating the whole guidelines, the memorandum, etc., and told the government notified in the official gazette. So if there's a vacuum in the law, there was a vacuum for sexual harassment of women in workplaces. So till Parliament steps in, Supreme Court can legislate, but only to the extent it is to protect fundamental rights. Similarly, when these women were being burnt, there were dowry deaths, kerosene stoves burst, and there were dowry deaths. There's no policy. The Supreme Court can lay down policy, but to protect fundamental rights. But where Supreme Court acts when there's no fundamental right involved, it would indeed be exceeding the jurisdiction. A good example is the case of national anthem case. We all respect the national anthem. It's very laudable that everybody should stand up when it's being played. When we go to the movie halls, there's a direction. First play national anthem before the movie starts. Excellent. But whose fundamental right was involved? From where did the Supreme Court get the jurisdiction to pass that direction? So the cases, according to, in my view, the test is the Constitution. If there's a fundamental right involved, Supreme Court has all the powers, because apart from the 5 traditional writs, Supreme Court can pass any order in the nature of the 5 traditional writs. So that's why compensation, Rudul Shah's case, though the first discussion came in Bagru Blinding's case. So if that is the standard, then that would be my yardstick, where I would say when the Supreme Court can intervene, when they cannot intervene. Then there are the secondary uses of PIL. Because of the faith of the common person in the judiciary, Supreme Court often offers a platform for debate. If you recall Mandal Commission time, there were immolations happening in Delhi, in the university. People were burning themselves protesting against the Mandal Commission report. The minute the matter went to the Supreme Court, everything died out. That was the forum for debate. So whether it's farm laws, it has a secondary use. People feel we have a platform where we can say what we want to do, what we want to say. So PIL, in my view, for the purpose for which it was conceived was very different for what is being used right now. For what it was being used, there are a lot of scholars who talked about after 1975 emergency, there was a political vacuum. Every institution lost its credibility, including the Supreme Court for the ADM Jabalpur's case. It was the free press, the Hussain Khatun's case, the lawyer couple, Kapila Hingorani, N.H. Hingorani, who moved the Supreme Court on the basis of press reports in the Indian Express, which had been written by K.F. Rustamji. The Supreme Court intervened. Why did it intervene? Every country in the world has a constitution which says you must pass orders to do complete justice. So it's not a question of provision. What made the Supreme Court intervene? Why was it the judicial will to intervene? And the answer of many scholars is to capture the political vacuum. To get into the political vacuum which was there post-emergency. And the government is in a catch-22. If the government agrees to what the court says, because the court says this is your job, we are only assisting you in doing your own job. You're not able to do it, so we are doing it for you, or we are helping you do it. If the government says we accept, it shows that the government is completely incompetent. I'll just stop. And if the government objects, it shows government is condoning the lawlessness. So that's where the situation happens, where it's a catch-22 situation. But I'll stop here, taking the cue from the chairperson.
I would just add one point to that. Now, should judicial activism be a temporary phenomenon, as former Chief Justice Ahmadi asked, because is it because of legislative non-activism and executive inaction that the judiciary was forced to be hyperactive? And therefore, should it be a temporary phenomenon? And Justice Ahmadi says, I wish it would be a temporary phenomenon, because of the quantum leap in the faith of the people in the Supreme Court and in the Constitution of India, one incidental consequence is it has added to the load of adjudicatory process. They will understand the systematized constraints that everyone talks about what is called docket explosion, but one of the reasons is this. Maybe common man has become active. Therefore, where do you draw the line? Or will we go back to the United States New Deal program days, where Frankfurter said you should not enter political ticket, and the US president was forced to say, I will pack the court with my men if the court doesn't go down. Now perhaps you are seeing a revival after Trump has come in the United States. And therefore, where do you draw the line? That's a very pertinent point raised by Honorable Shaikh. Thank you.
Siddharth Gupta, our eminent panelist, to respond. There are two more issues which I would like to be flagged if they are covered by Mr. Siddharth Gupta or by our other eminent panelists during the course of discussion. One is limits on activism. Union Carbide, since we are sitting in the city of Bhopal, Union Carbide took place in 1984, almost 40 plus years. The role of parents parenti assumed by Supreme Court. There is still an undercurrent that if the Virginia standards would have been followed, compensation would have been much different. Yeah, strict liability, strict liability. That's Fletcher's case, if I'm not wrong. Another issue is that what impact social media can have on activism. I'm reminded of one movie which I saw in my school days. That was Kamla. It was by one journalist, Mr. Sareen, if I'm not wrong. If I'm messing up the names, please excuse me for my age. Now, the issue is that Kamla highlighted the issue of human trafficking. And that was taken up. So there are various sources of judicial activism. Whether, as Mr. Hingorani said, that should courts wait for the lawyer or a litigant to approach them, or they can take a clue from social media and act on it. I think these issues too need deliberation when we are talking of activism and judiciary. I now invite Mr. Siddharth Gupta. He says that I have cut on his time. He has prepared a brief for 20 minutes, but as a good lawyer, he will finish it in 10 minutes. Thank you.
Honorable Mr. Justice Vivek Agarwal, respected Professor Venkat Rao, respected Mr. Aman Hingorani, all my respectable faculty members, senior professors, eminent jurists, office bearers of the Student Bar Association, volunteers, all the students present in the audience. First 2 minutes, which should not be counted in my speech, I would like to pay my respects to my teachers and faculty who taught me for 5 years, 20 years back. I am coming here after 19 years, exact 19 years, on this side of the audience. I passed out in April 2006.
And but you cannot blame your teachers for what you are today.
Sir, it is said, failure is collective, success is always individual. But in this case, failure is mine, success is because of my teachers. There cannot be a better occasion to thank all those faculty members, because of whom only I stand here today on my legs. कबीर दास जी ने गुरु शिष्य के संबंधों का बड़ा पवित्र तरीके से वर्णन किया है. उनसे किसी ने पूछा, मैं एक दोहा कहूँगा, गुरु गोविंद दो खड़े काके लागू पाए, गुरु गोविंद दो खड़े काके लागू पाए, बलिहारी गुरु आपनो जिन गोविंद दियो बताए. कबीर दास जी से किसी ने पूछा, अगर मेरे सामने गुरु और गोविंद अर्थात ईश्वर खड़े हों तो मैं किसके शीश नवाऊं, किसके पैर छूं, चरण स्पर्श करूं? कबीरदास जी कहते हैं पहले गुरु के करो, क्योंकि गुरु ही आपको गोविंद तक ले जाते हैं. There cannot be a pleasure bigger than seeing my former teachers, mentors, guides. I met Professor Gayud sir, Raka ma'am, Uday sir, Monica Raje ma'am. Many of them are not here today. Dhiren sir, I'm sorry. Rajiv sir, after so long. And I felt that 2-3 minutes I should take out from my speech to thank you all from the core of my heart. Now coming to my topic. Though the topic, I was told that the topic is umbrella, I can select a specific subspecies from it. So my topic today is activism and restraint, judicial restraint as two sides of the same coin of judicial review. Justice M. Hidayatullah, in one of his landmark articles he wrote in 1984, he said about judicial activism, there are two ways of skinning a cat. You can do it very quietly, or you can do it ostentatiously. The task of judicial skinning or judicial interpretation, therefore, in my opinion, can be done either quietly or ostentatiously. I am fortunate to be sharing my dais today with Honorable Mr. Justice Vivek Agrawal. He was elevated on the bench exactly 9 years back in April 2016. And at the threshold, I must say, to my limited experience and exposure to his style of working before shifting to the Supreme Court in 2022, he is one of those rare, very few judges who has been doing this task of judicial skinning very quietly and gracefully. I am personally an ardent proponent of judicial activism. I am personally, my speech was prepared, sir, 2 days back. I am personally an ardent proponent of judicial activism. When we talk of judicial activism, the first thought strikes our mind are judgments which are out of the box, which are away from the vestiges of procedural technicalities and restrictions, having the temperament and nature of something which is outside the procedural rigors of the judicial institution. However, judicial activism, in my opinion, should not be treated as an anti-government or an anti-establishment approach. I'm having less time, my time is fixed, so I'll quickly move through. I'll give 2 examples from 2 different countries of 2 different continents, and both are related to each other. There is a book all of you, the law students, must read, Remarkable Trials of All Countries, New York, published by Thomas Dunphy and Thomas Cummins. It talks about a real-life incident of a trial that took place in the beautiful island nation of Malta, European nation. There was Judge Cambro, who one fine winter morning, through his window, he was having a hot cup of tea, and through his window, he was seeing the greener pastures. He sees an assailant stabbing a knife. Suddenly a murder happens in front of his eyes. The assailant stabs a knife in the belly of the victim, and on spotting that somebody is coming, he fleds from the spot. The victim is lied profusely bleeding, and the constable, on a SOS call given by the victim, comes rushing in. In the meanwhile, a kind, gentle-hearted baker was passing through, who comes to the rescue of that victim, tries to pull out the knife from his belly, which was stained in blood, obviously. The constable comes at that point of time to his misfortune, and he catches hold of him, arrests him, and sends him to custody. Because Judge Cambro was the only judge at that point, I'm talking of the 17th century, he was the only judge in the whole county. So by doctrine of necessity, he was the one required to he was the one who tried that gentleman, the baker. Now, after the evidence, in light of the evidence produced by the prosecution, the defense which came before him, he found the baker guilty and convicted him of murder. Now, when the trial was going on, there was a huge outcry. There was no social media at that point of time, but there were media outlets. there was huge public outcry as to why this baker is being tried. But Judge Cambro convicts him, finds him guilty, and sentences him to the punishment. Now, I pause here. Would you label Judge Cambro as activist or conservatist? In my opinion, Judge Cambro was an activist judge. Why? Because he did not succumb to public pressure or public perception. He did not get carried away by his preconceived notion or personal belief. He went by the evidence that came before him, the defense that was adduced, and the case of the prosecution. This was from the UK. Now coming to the US, altogether different example, few minutes back Professor Venkat Rao gave. In 1930s, many of you must be aware, there was a great economic depression in the US because of steep stock crash. So President Franklin D. Roosevelt introduced a series of measures known as the New Deal legislations. These were social welfare legislations, minimum wages, minimum working hours, insurance, health guarantees to be ensured by the employers and the industrial houses, the corporates. Now, the Supreme Court at the relevant point of time had 9 judges. The Supreme Court of US, I'll address as SCOTUS, quashed all the legislations as unconstitutional, holding it to be violative of freedom of contract and against the economic theory of laissez-faire. They all were struck down. Editorials, media outlets hailed the SCOTUS as the protector of people, as judicially active. So much so that after a year, the depression, the economic depression worsened, and poverty, unemployment, and resultantly law and order also went from bad to worse. So much so that Franklin Roosevelt issued a press release. He'll pack up all the 9 judges, fill the SCOTUS with judges who exercise restraint in interfering with the New Deal legislations. Now, the judges switched their stand. They adopted a restraint attitude of not interfering with these legislations, and that's how the famous quote came, "A switch in time saved the 9." That means a switch from the activist approach to the restraint approach saved all the 9 judges, because there were 9 judges in the Supreme Court. The point I'm trying to drive home by virtue of these 2 examples is that judicial activism is in public interest is a perception. It may not always be the New Deal legislation. We cannot adopt a results approach when judging whether judicial activism is good or bad for the institution or the country. There has to be a means approach. Now, what is the means approach? The means approach is, which has evolved traditionally over centuries, and some may label it as a conservative or an orthodox approach, is that giving a fair, just opportunity to all the parties before the court to present their case, exchange pleadings, counter each other's stand, then following the binding precedents, stare decisis, supported by reasoning on every finding, returning a conclusion or an outcome, final outcome, as to why this finding is rational, germane, and nearest to the facts and circumstances of the case. In my opinion, this is the means approach for assessing whether there is actually judicial activism on the part of the court or the judge. Now, scholars are greatly divided over judicial review, judicial activism, judicial restraint. There may be improper judicial review, but proper judicial activism. I gave example of New Deal programs a few minutes back. This is that example where there may be improper judicial review, but a proper judicial activism, which means in public interest, judicial activism is not warranted. On the other hand, there may be proper judicial review, but an improper judicial activism. This is those cases where the judiciary at times is expected to be proactive and rise to the occasion to protect the rights, constitutional rights, fundamental rights of the citizen, but it fails to do so. And the fitting example of that is the case of ADM Jabalpur versus Shivkant Shukla, where the judiciary went more executive than the executive itself. Both of them are on the 2 extremes. Both of them are definitely not conceived under our constitution. Now, the question arises is, there is always a debate whether judges should legislate or not. And it is said a judge says or holds what the law is. He is not supposed to be holding what the law ought to be, what the law should be. But once O.W. Holmes, the Supreme Court judge, US Supreme Court judge, he said, what judges do is legislate only always, but interstitially. The legislation by the judges is at the molecular level as a necessary adjunct to their very exercise of judicial decision making. In other words, judges, whilst interpreting the law, are justified in filling the gap or the interstices. All the students here must have heard of the celebrated judgment of Donahue versus Stevenson, also known as the snail in the ginger bottle case. A snail was left due to negligence by the manufacturer that reached the end customer, the lady who fell ill after consuming it. Now,
Sorry to intervene. In the Indian context, there is a judgment of Justice R.C. Lahoti in P. Ramchandra Rao versus the State of Karnataka, 2002 4 SCC 578. With your permission, I quote it.
yes.
Courts can declare the law, they can interpret the law, they can remove obvious lacuna and fill the gaps, but they cannot entrench upon in the field of legislation properly meant for the legislature.
Yes, that's what I was proponing, that courts can fill in the gaps. Yes, I am grateful. I am grateful. Now, so I was referring to Donahue versus Stevenson, where Lord Atkins elevated the neighborhood principle and inferred a duty of care on the part of manufacturer to the end consumer. This was followed later on by Lord Reed in 1917 in Home Office versus Dorset Yacht Company. What I'm trying to say is, by the very purpose and the nature of duty conferred on the judiciary of interpretation of statutory or constitutional provisions, there is an element of innovation inherent in it. Therefore, I said it has to be always tested on the basis of the means approach. Now I come to the next part and the last part before concluding. Judicial activism, is it good for the country or it's a boon or the bane, like rightly his lordships used in the beginning? I'll give two examples. In 1998, the judgment of P.V. Narasimha Rao versus State, the Supreme Court was confronted with the issue of interpretation of scope of immunity available to the legislature who had taken a bribe. There was a no confidence motion moved against P.V. Narasimha Rao government. Certain MPs had taken the bribe. Certain people voted against the no confidence motion. Certain people whose conscience got awakened at the last minute, they took the bribe but they did not vote. Now, both were being prosecuted and the matter reached the Supreme Court. Interpreting Articles 94 and 105 in 1998, it was held that those who took the bribe and voted will enjoy the immunity because they have exercised their right to speech and vote within the precincts of the parliament, and therefore they enjoy the immunity. Whereas those who did not vote will not enjoy the immunity because they have not expressed themselves. Now, at the relevant point of time, this was a 5-judge bench. There were two schools of thoughts. One school of thought had inferred, had labeled this approach of the Supreme Court as being text-driven of the Constitution, being pedantic, whereas there was other school of thought which had termed it to be sticking to the spirit of the Constitution, which meant the according immunity to the legislators. This view continued for more than 25 years, and last year, 7 judges bench overruled P.V. Narasimha Rao, holding that what we'll see is the constitutional morality. The constitutional morality behind interpretation of any constitutional provision, the purpose, object of the immunity available to the legislatures. it evolved the nexus and the necessity test to hold. The judgment is very long. I'll just sum up. To hold that the necessity and nexus test mandates the courts to review it. I stress on the word mandates the courts to review whether the claim for immunity has bona fide relation to the discharge of duty of the parliamentarian. If the bribe is taken, it falls outside his duty. It's a criminal misconduct which cannot protect him. Now, obviously, we may hold the previous verdict as being judicially active or the subsequent verdict as being judicially active. The fact is, there is a constitutional process, there is a judicial process through which the law evolves. What was constitutionally moral in 1998 was treated immoral in 2025. The other judgment, other example is, in 2017, Supreme Court, in the case of Asian resurfacing, issued set of directions that an interim order, this was to deal with the docket, the bursting docket and huge pendency in the courts of the country, passed an order that interim order passed by any court shall have a lifeline of 6 months, whereafter it will get expired automatically. I myself saw a lot of articles, editorials, columns in newspapers, heaping bunch of praises on this verdict, that this will be a milestone towards tackling the pendency. There was one more direction, that after the interim order is vacated, regardless, the courts would be duty bound to decide the trial at the earliest. Like I said, the editorials were all in praises for this verdict. But after 1 year, this verdict became a pain in the neck for the institution itself. I was practicing in Madhya Pradesh High Court at that point of time, and Lordships must be aware, if there were 150 cases listed before any court, 40 to 50 cases were those where application was filed for extension of stay beyond 6 months. So much so, this became so much so that even if an interim order was passed after hearing both the parties, a reasoned interim order, it is automatically stood vacated, and the parties were nowhere. So eventually, on an application moved by Allahabad High Court Bar Association in 2024, the 5 judges constitution bench toppled the 2017 verdict. And let me tell you what has been held in that. It has been held that the 2017 verdict was per incuriam. It amounted to judicial legislation, and the unanimous verdict says that whilst performing judicial functions, judiciary should not legislate or entrench upon the domain which is meant for the legislature. It has further been held in this judgment by the Supreme Court that if a judicial order is passed, it cannot be vacated automatically through a direction passed under 142 by the Supreme Court. So that takes me to the moot question and my concluding remarks. Judicial activism is like that celebrated proverb, beauty lies in the eyes of the beholder. It depends from the perspective, from the ideology you're looking at any judicial verdict. If you see from a prism which is dark, you'll find the judicial verdict to be conservative, to be orthodox. But if your prism is colored, then you'll find that activist. Therefore, the approach should be neutral, objective, and without any ideology or value-laden approach. Judicial activism and judicial restraint, in my opinion, therefore, are two sides of the same coin. The name of the coin being judicial review. I am thankful to the organizers, the SBA members, volunteers for organizing this function very successfully. I am thankful to my interns, to my 4 interns, Soumya, Samriddhi, Khushi, Vedanshi, who had helped me in preparing the PPT, which you saw on the screen, and also my script. Thank you very much, everybody. Jai Hind.
Siddharth was speaking about the impact assessment of activism. I would just add to that and raise a question. Public perceptions and community expectations in administration of justice have increased so much that has activism become counterproductive in the practical administration of justice because of public perceptions and community expectations?
One more comment on Siddharth's presentation, that UK judge Carlson or
Cambro.
Cambro brought a thought to me that whether one can be a judge in his own course. Since he was a witness, was he entitled to try that case?
Yes, sir.
I think that issue, before we take any moralistic stand in favor or against, also needs to be discussed in a wider context of judicial activism. And I am reminded of one small anecdote. When I was a lawyer, I was traveling in a taxi, and those were the times when courts were pressing hard for conversion of diesel vehicles into CNG vehicles.
Delhi mein.
Delhi. My taxi driver was a Sardar. As a lawyer, I was traveling with my client in that taxi to brief a senior counsel. That issue was different. That had nothing to do with CNG. That driver commented, "Saab, सरकार जो काम खुद नहीं करती वो इन लोगों से करवा लेती है." Now, activism is to be judged in that context also, that whether we are taking the role of governments to save the government from taking unpopular measures which may seem unpopular at the threshold and which may be beneficial in the long run. Now, with the permission of my co-panelists, I've opened the floor for question answer, and any question is most welcome. You will do one thing good, that first identify yourself, ask your question, and if you have any specific panelist in mind, then you can direct that question to a specific panelist. Thank you very much.
Hello. First of all, my greetings to all the dignitaries, intellectuals, and my courageous comrades who are present here. My name is Sahil Samdaria from Sage University, Bhopal. Sir, yesterday there was a honorable judge was sitting there from the Apex Court of India, Mr. Pankaj Mittal, sir, and he suggested that the book of Gita, religious book, and other religious sculptures of Hinduism.
Mr. Speaker, please restrict your questions
Okay.
to this session only, because we are already running behind the schedule. We will appreciate that if your questions are directed to the discussion centered in this session, that is Supreme Court and judicial activism.
Okay, what's the question are totally unrelated to this regarding the yesterday session. So should I?
We'll reserve that for informal discussion over a cup of tea. When we meet over a tea or something, then we can discuss your queries,
Okay,
please.
no problem. Yes.
So don't mind, but we'll have to maintain some discipline.
Good morning, esteemed panel. My question with regard to today's discussion is, sir, with increasing judicial intervention through PILs, how can we ensure that activism remains constructive, and how can judiciary, maintain the public trust in the age of social media, where criticism is spreading instantly and without compromising its institutional dignity or appearing intolerant through contempt proceedings? Thank you.
Self-restraint is the answer to your question. You have to balance activism with self-restraint.
Thank you, sir. Really grateful for this insight.
Good morning to the panelists. My name is Priyanshu Gupta, and my question is with respect to the discussion which was going on. Initially, the panelists discussed about judicial activism and judicious activism. In that respect, we also come with the point where we see that a blame is also given to the litigants, that we as a litigant bring every matter in front of the court, and therefore courts are compelled to give a decision on the same. In that context, my question is, how do we strike a balance between judiciary being progressive and not overreaching, and who ultimately bears the burden of judicial activism, the court or the litigants?
In one sentence, I would say, citizens have been elevated to the status of citizens from that of being subjects through judicial activism. Now, before judicial activism, there was no dignity, and citizens were like constitutional orphans. And from that stage of constitutional orphans, they have been lent dignity and they are elevated into the status of citizens. This has been the greatest contribution of activism.
I would like to supplement what Professor Rao said. See, all the three wings of governance are required to balance each other. There was a talk, there is a policy, a litigation policy of the state of Madhya Pradesh. I would suggest that a copy of that policy may be obtained and be circulated amongst all the students of at least final year. Why I am emphasizing on state litigation policy? Because it says that there will be an endeavor by the state to constitute appropriate expert groups for ventilation of grievances of the citizens under different areas. Now, if that policy comes into operation and it is implemented properly, then half of the woes, if I'm not exaggerating, can be sorted out at the administrative level itself. It is the indifference of one organ of the governance which makes the courts to overreach or to show activism or to decide cases. I'll just give you one example. In one of the cases, Honorable Supreme Court says that if the normal date of increment of an employee is 1st July, then anybody and everybody who is retiring on 30th June will be entitled to that additional increment which falls on 1st July. After having said that, failure of one wing of the governance to not to implement that order across the board resulted in at least filing of 4,000 to 5,000 petitions in the High Court of Madhya Pradesh alone. So this is the level of docket explosion. This is the level of harassment to the litigant due to inaction on the part of one of the wings of the governance. So there has to be balance. Every wing has to be proactive. Every wing has to do its best so to deliver the best to the citizens of the country.
Thank you to the panelists for the insight.
Greetings to the panel. My name is Priyam and I am the final year student at NLIU Bhopal. Sir, my question to the panel is, in 4th year we are taught a subject, interpretation of statutes, in which we are taught literal rule, golden rule, mischief rule. So in this context and in the context of judicial activism, is it correct to say that the judges should stick to the literal rule and hardly resort to mischief rule and golden rule? And is this approach correct, whether sticking to the literal rule is not judicial activism and going to the other rules is judicial activism?
See, may I take this question? Thing is that there is no straight jacket formula which rule is to be adhered to. But what Mr. Hingorani said, I agree with him, that there should be a broad consensus so that there is uniformity across the board. That in which situation, which rule should be invoked, should not be left to too much of discretion. There should be, I am not a votary of taking away the discretion of the individual, but there should not be too much of discretion, so to leave two kinds of situations for a same set of problem.
Sir, very warm and pleasant good morning to respected panelists. I am Ajay Prabhash Tiwari from LNCT University, and my question is from panel. Does judicial activism create toss with theory of separation of power?
As I mentioned, we don't have a strict application of separation of power. So if the courts are doing what they're expected to do by the Constitution, there are certain duties and obligations imposed by the Constitution. If the court is charging its own obligation, then obviously there's not a question of negating separation of powers. So, I mean, I would put it to that. Of course, I would, like I said, put it different phases, and when you're working in the adversarial system, there is sufficient differentiation that the courts cannot get into executive functions or legislative function, cannot lay down policy, cannot make down laws, etc. Once you get into PIL, ideas to protect fundamental rights, to the extent it's necessary to protect fundamental rights, courts can legislate, court can impinge on policy issues. So it depends on the nature of the case. It depends on what is the role, which is a broader issue. Is the judicial role around the world the same? Is it only adjudication, or is it something more? So where the Constitution permits, or at least does not prohibit the court from assuming a particular role to achieve the end specified in the Constitution, I think it's legitimate. It's not a negation or separation of powers.
Since time for this session is over, I request, with the permission of the Honorable Vice Chancellor, that two more questions, if any, and then we wind up. Just two more questions.
Sir, very good morning actually. It's not yet afternoon. So I'm a third year student at NLIU Bhopal, and my particular question is with relation to the powers of the Supreme Court when coming to drafting certain things that are the prerogative of the legislature. So for example, perhaps the POSH guidelines. So the Vishaka case came in. There was a mandate that was required because there was a legislative vacuum that was filled. But again, does the court actually have the expertise to step into the shoes of the legislature and then determine things what should be the law? Because that, again, it would be somewhat completely taking over the prerogative of the legislature when it does that, formulating guidelines so to that effect.
Well, if you see all these judgments, they normally have a caveat. Till Parliament steps in, this will govern the field. Now, if there's a vacuum in law or policy, and somebody's fundamental rights are being violated, if women are losing on their dignity because they're being sexually harassed, and there is no provision, there's a vacuum, and the court's obligation is to protect fundamental rights, what can the court do? So it's not a question the court being the best forum to legislate. It has no option but to, in discharge of its own obligation, to legislate till Parliament steps in. So whether it's Vishaka, whether it's Lakshmikant Pandey's case, where adoption of Indian children by foreigners, if there's a vacuum, and the court needs to protect the rights of those Indian children, the court can't keep waiting for the other organs of the state to act. So that's why in the interim period, if it comes in, and we have seen more or less the legislation does, the law that does get enacted, more or less continues what the court has done. So the court is not doing a bad job at the end of the day.
I would also add, just kindly go through the catena of cases to understand the judicial process regarding socio-economic issues on the one hand and civil and political rights issues on the other. That will give you a better comprehension.
Before handing over mic to my dear friend Siddharth for his comments, one perspective from my side also. You will have to categorize and analyze different stakeholders or the different persons at the receiving end. I would like to give an example, and if I'm not too off the mark, subject to correction by my eminent panelists. Vishaka case is one case where we were dealing with the rights of the women, exploitation of women at workplace. Now, that was the pressing need which could not have been allowed to wait for the competent authority to fill the lacuna. Whereas there are other cases like common civil code. Supreme Court on several occasions have observed that there is a need for common civil code, but they have restrained from enacting a common civil code on their own. So why I am giving this example, this explains the areas where Supreme Court has been proactive, because women being the intrinsic part of the society, very important half of the society. Whereas if there are other areas which can wait for the legislature to act.
Thank you, sir. I think the latest example in point is the judgment in the case of Tamil Nadu by Supreme Court 2 days back. What the Supreme Court held, it fixed a timeline for the governors to respond to the bills forwarded to it. Otherwise, it was held that there will be a deemed consent, and yesterday you must have read that one of the states treated the legislations to have been duly approved by the governor as being deemedly approved. Now, there are two schools of thought, that whether there has been judicial or a constitutional drafting by the judiciary, or filling in the gaps when the governors were just sitting tight over the bills. So, just stretching forward what Honorable Justice Agrawal said, that where there is a lacuna, the palpable lacuna, which is coming in the way of a transparent governance, judiciary is under the Constitution of India duty bound to step in. Because we do not follow that watertight separation like the Montesquieu theory of the three wings, like it happens in the UK courts.
See, if you take it on the other side, it is like a women's exploitation is a case of a patient which was required to be taken in CCU, critical care unit. And there the level of activism and the stage of activism will be different from a case which is of a OPD types. So we'll have to distinguish between the facts, whether the case is of a outdoor patient unit or of a critical care unit. Last question, please. Thank you very much. Thanks for your patience, and I think that our discussion must be useful for you, and it will open new vistas for discussion amongst yourselves to come out about the pros and cons of judicial activism. Thank you very much. Thanks my panelists, Dr. Rao, Dr. Hingorani, and dear friend Siddharth. Thank you very much.
Thank you so much, sir. We now conclude the first panel discussion for today. We'll resume the next panel discussion after a short break. I request all the participants to kindly remain seated as the dignitaries would leave and try to make way for them.
I request everyone to be please seated. We'll shortly be beginning with the session. Everyone sitting at the back, please come to the first seats. Everyone sitting on the back seats, please occupy the front seats.
A very good afternoon to our esteemed dignitaries, respected faculty members, and students present here today. My name is Shwena Nindur, and it is my absolute pleasure to welcome you all to the fourth panel discussion of the first NLIU SBA Long Conclave 2025. Today, it is our privilege to host an extraordinary panel of guests. I extend a very warm welcome to Honorable Justice Shri Dinesh Kumar Singh, our respected chair, Professor K. Madhusudana Rao, our esteemed co-chair, and Professor Dr. Archana Ranka. Let us take a moment to express our heartfelt gratitude with a warm round of applause for our esteemed dignitaries. We are truly honored by their presence here today. As a token of our heartfelt appreciation, we are privileged to present them with a miniature statue of Raja Bhoj, a symbol of enlightened leadership and timeless vision. Alongside, we offer a handmade shawl representing rich cultural heritage and enduring traditions of Bhopal. I now request our Honorable Vice Chancellor, Professor Dr. S. Surya Prakash, to kindly felicitate our esteemed panelists as a token of our gratitude and appreciation. I kindly request Vice Chancellor Sir to felicitate Honorable Justice Shri Dinesh Kumar Singh. I kindly request Vice Chancellor Sir to felicitate Professor K. Madhusudana Rao. I kindly request Vice Chancellor Sir to felicitate Professor Dr. Archana Ranka. Thank you, sir. It is an honor to be able to witness this thought-provoking panel on the Supreme Court and religious rights, a theme that continues to resonate deeply in India's constitutional discourse. Before we delve into the intricacies of this topic, it is most appropriate to acknowledge the invaluable contributions of our esteemed panelists. It is our privilege to introduce our chair for today's session, Honorable Justice Shri Dinesh Kumar Singh, Judge at the Kerala High Court. Justice Singh graduated with an LLB from Allahabad University and completed his LLM from Delhi University in 1992. He began his legal practice at the Allahabad High Court before moving to the Supreme Court in 1998, where he practiced in matters of constitutional law, administrative law, commercial laws, arbitration, and criminal matters until his elevation to the bench. Justice Singh was appointed as an additional judge of the Allahabad High Court in 2017 and became a permanent judge in 2019. In 2023, he took oath as a judge of the Kerala High Court. Known for his sound legal reasoning and commitment to constitutional values, we are honored to have his insights today. We welcome you, sir. We are delighted to welcome the co-chair for this session, Professor K. Madhusudana Rao, Senior Professor of Law at Andhra University. With a distinguished career spanning decades, Professor Rao has made invaluable contributions to the fields of constitutional and administrative law. He is widely respected for his academic rigor, research contributions, and his role in mentoring generations of legal scholars. His expertise in public law and his deep understanding of constitutional principles make him an ideal voice in today's discussion. Welcome, sir. It is my honor to introduce Professor Dr. Archana Ranka as the panelist for this discussion. Head of the School of Law at Devi Ahilya Vishwavidyalaya University, Indore, she has over 15 years of teaching experience and is a respected academic and administrator in the field of legal education. Her areas of research include family law, cyber law, gender justice, and social legislation, and she has contributed significantly to curriculum development in legal education. Her perspectives will surely enrich today's panel. We welcome you, ma'am. We are grateful to have all these respected luminaries with us here today. I would now request our chair for the session, Honorable Justice Shri Dinesh Kumar Singh, to kindly commence with the panel discussion.
Good afternoon, everyone. My co-sharers, eminent Professor K. Madhusudan Rao, Madam Archana Ranka, another co-panelist. Judge, when he is deciding, it's most easy for him to decide the cases because he gets assistance from both sides. Here, the role is different. I don't get assistance, but I have to start the discussion. So that's the role is reverse, which I used to do it before I got elevated. Anyway, this is the call which I have accepted, and therefore I have decided to chair this session. The topic is very interesting and relevant also for the present, the situation which is prevailing in the country. In 1947, when the India became independent, the country was divided on religious lines. A particular people practicing particular faith, the leadership of that faith wanted the separate country for themselves. Whatever the situation was at that time, I think leadership was also tired, not have enough patience to continue the struggle for a long time. India got divided, and the dominion, initially it was two dominions were constituted. They became independent countries. The second dominion further got divided, and it became Bangladesh and Pakistan in 1971. The country which separated chose to be a religious or the theocratic state, but the framers of the constitution, going by the ethos of the population and the country, they chose the path of secularism And therefore, the preamble itself provides the liberty of practicing conscience besides liberty of thought and expression. The four goals which the framer of constitutions they aspire to achieve for the country, one besides the equality, liberty, fraternity and justice. Liberty was also one of the goals which was thought of for achieving. To achieve this, the Constitution does not stop there only providing the goals only, but there are the fundamental rights guaranteed to achieve, to guarantee those freedoms. That is Article 25 to 28 and 29 to 30. That where a citizen has a right to practice, profess, propagate their religious belief and also manage their institution, construct the institution. Now these freedoms of religion are not the same, or they have not given the equal status. They are subject to the other parts, other provisions of Part 3. Therefore, when it comes to Article 14, 19 and 21, which is a golden triangle of Part 3, the Article 14, 19 and 21 will have supremacy over Article 25 to 28 and 29 to 30. Those are for establishing that guarantees minorities, religious and linguistic, to establish educational institutions of their choice. One must understand that why these freedoms have been guaranteed in the country. This is not only how you practice, how you perform your puja, but the Indian ethos is deeply rooted with the concept of superpower and interconnect with it. Otherwise, in Kumbh, recently concluded Kumbh, around more than 40 crores people came to Prayagraj from all over India and abroad. And I myself visited twice. So this is the ethos, this is very deeply rooted, the concept of some spirituality, some interconnect with superpower. It's not only following a particular religious text, particular form of the puja or the ibadat or archana. This is a way of life, as Justice Verma in two of the celebrated judgment in 1994 said, the Hinduism or Hindutva is not a religion, it is a way of life. And that is the essence of Bharat, that is the essence of India. Realizing this, the framer of the constitutions gave that right, but they also said that the country must strive to enact the common civil code or uniform civil code in Article 44 of the Constitution of India to regulate non-religious or secular aspect of the society, right of property, right of marriage, right of other things, where they are not the very basic or the part of the religion. What are the essential practices of the religion, what are non-essential practices of religion? the Supreme Court has laid down from 1994 onwards. And in recent case in Saira Banu in 2017, Supreme Court said that triple talaq is not an essential practice of Islam. It is against the guarantee, equal guarantee to the women under Article 14 and 21, and therefore it is struck down this practice as being unconstitutional. So Supreme Court, in several judgments, I am not going because this is a very small, I am chairing this the session, and my brilliant two co-panelists are here who will deliver on this thing. I can go on for very long. So Supreme Court said that what are the essential features or essential practices which are related to religion and which are not the essential practices which are not related to religion. Those which are not essential can be regulated by the state. And in Ram Janmabhoomi case, the Supreme Court said that offering namaz in masjid is not an essential practice of Islam. In Sabrimala, though I may or may not agree because day before yesterday I went to Sabrimala and came here. So I may not agree with the judgment of the majority in Sabrimala, where the Supreme Court said that barring women to visit the temple a particular age is against the rights guarantees to them, and therefore it struck down that practice where visiting Sabrimala for a particular age of women was barred. Anyway, I am not going to that. That judgment is under review. It's pending for the Supreme Court. So therefore, the issue which you have chosen, that religious right and Supreme Court, I will, when I deliver the last lecture, then I will deal with in detail. But for panel discussion, this is enough to say that whenever the Supreme Court has found that a particular practice is not an integral and essential part of the religion, then Supreme Court has come down against that practice and declared it unconstitutional, where it is triple talaq or visiting particular age group women to the Sabrimala or the Haji Ali. The Supreme Court has struck down those and has upheld the supremacy of Golden Triangle, that is Article 14, 19 and 21 of the Constitution of India. So this Supreme Court has to balance, and rightly so, the liberty and the fundamental rights guarantees to all citizens of India and the religious rights which are guaranteed to the person who is practicing that religion. And Supreme Court has given primacy to this Golden Triangle in its pronouncement from 1954 till 2017. Therefore, as I see and as I can understand from the judgments of the Supreme Court, that the court, while resolving the conflict between Article 14, 19 and 21 and the rights guaranteed under Article 25 to 21, has given primacy so that the public order, morality, the right to life and liberty and equality have given primacy than the rights of religious rights, which are individual rights and rights to particular denomination. Thank you. I will hand over the mic to the co-panelist, Professor K. Madhusudan Rao, to give his lecture.
Honorable Justice Dinesh Kumar Singh, sir, Judge High Court of Kerala, Professor Archana Ranka, Professor Surya Prakash, Vice Chancellor, NLIU Bhopal, my Guru Professor Venkat Rao, distinguished judges, distinguished invitees, my colleagues and my student friends. Indian Constitution provided not only religious freedom, but also secularism. Secularism as such is not similar to that of the secularism that is existing in the Western countries, especially US. In US, there is a wall of separation between state and religion. The First Amendment of the American Constitution says that the Congress shall pass no law for the establishment of religion or prohibit the free exercise thereof. Establishment clause and free exercise clause, two clauses are there. In India, we have not established a non-establishment clause. And at the same time, free exercise clause also is subject to certain limitations. So then, what is the outer limit of secularism in India that we have to consider? The following provisions of the Constitution, which I am going to enumerate, will delineate the scope of secularism in India. For example, Article 16, Clause 5 recognizes the laws for the establishment of religious institutions and requirements of religious institutions for appointment of any person to those institutions. Then Article 28, Clause 2 envisages the state itself is managing the educational institutions in which religious instruction can be imparted. That is Article 28, Clause 2. And then Article Entry 28 of List 3 provides for legislative competency to both the Parliament and the state legislatures to enact laws on religious institutions and religious endowments, including charitable institutions and charitable endowments. And another most important article that was added by the Constitution 7th Amendment Act in 1956, immediately after the reorganization of states. That is Article 290, capital A. This article says that the government of Kerala has to pay 46,50,000 every year to the Travancore Devasam Board. And the state of Tamil Nadu has to pay 13,50,000 to Travancore Devasam Board. What for? For the board, for the temples which are to be managed by the Travancore Devasam Board, because these temples previously were to be managed by the Rajas of Travancore Cochin. By virtue of this instrument of accession, at the time of reorganization of states, these empires are merged into Indian Union. These princely states were merged into Indian Union, and previously these temples were to be maintained by these states. Accordingly, this obligation is laid on the state of Tamil Nadu and the state of Kerala for paying this money to the Travancore Devasam Board, which is now maintaining these temples. Whatever secularism we envisage under the Indian Constitution is subject to these conditions. And then if we enter into Article 25, Article 25 says that subject to public order, morality, health, and other provisions of Part 3 of the Constitution, 4 restrictive grounds are provided on religious freedom. Public order, morality, health, and other provisions of Part 3 of the Constitution. Other provisions of Part 3 means, for example, Article 17, untouchability. So in the name of religion, if there is any untouchability being practiced in the society, that can be restricted. Consequently, the Protection of Civil Rights Act, previously known as Untouchability Offences Act, it is valid. Then what are the nature of freedoms that are provided by Article 25? Clause 1 says that, subject to public order, morality, health, and other provisions of Part 3 of the Constitution, the freedom of conscience, the freedom to profess and practice, and the freedom to propagate religion is guaranteed. The freedom of conscience means, according to one's own conscience, whichever religion he has faith, he can practice that religion and profess that religion. When the word propagate was taken up for discussion in the Constituent Assembly, the minority religions members in the Constituent Assembly gave the impression that the word propagate is mentioned in the Constitution for the purpose of guaranteeing a right to conversion. India is a multi-religious society. Even for protection of insignificant small religions, Constitution has to provide a provision. That's the reason why this concept of secularism is mentioned in the Indian Constitution. Now, if freedom of religion is subject to this, fortunately, the framers of the Indian Constitution have removed these communal elements in the Indian legislatures after the Constitution came into force. In the Constituent Assembly, communal representation was there. And this communal representation played its own role for the purpose of protecting their rights. Consequently, these provisions are provided. So whatever it is, the word propagate acquires the color that it includes conversion. But whether conversion is permissible under the present Constitution, some of the states have enacted laws. Orissa, Madhya Pradesh, Swatantra Adhinayam, Orissa Freedom of Religion Act. These laws have prohibited conversion from one religion to another on the ground of, on the basis of coercion. Generally, they have prohibited the conversion. People should not convert the person to another religion by means of force, fraud, inducement, or financial allurements. These laws were contested before the court, and the court stated that forcible conversion is against to Article 21, Article 25. Consequently, free conversions are permitted, forceful conversions are prohibited, said the court. Now, these proselytizing religions, they have started converting the people to their religions from another religions. So that is the reason why the court has accepted this, and the forcible conversion as such is not permitted right now. Then, what are the restrictions provided in the Constitution in Article 25 itself? Article 25 2A says that the state is empowered to enact a law to regulate the financial, economic, and other secular activity associated with religious activity. These activities, if at all there is a political activity or economic activity or any financial activity, that can be regulated by the state, though it is associated with religious practice. And Article 25 2B is more powerful in the sense that it empowers the state to introduce social welfare as well as social reform. In the name of religion, we have many number of evil practices going on in the country. Sati practice, Devadasi system, child marriages. So these systems, and then human sacrifice, animal sacrifice, these are going on in the name of religion. So for the purpose of providing social welfare as well as to introduce social reform, power is given to the state by virtue of Article 25 Clause B, 25 2B. And one more power given to the state is, we do not have social equality even in the matters of religion in our country. In order to introduce social equality, the state is empowered to enact a law to throw open all the Hindu religious temples of public character to all the sections of Hindus for worship. Why only Hindu religious temples? Why not other religious temples? Because the incidence of untouchability is prevalence in Hindu religion only. That is the reason why state is empowered to enact a law to empower the excluded communities to enter into the temple for worship. For these reasons, temple entry authorization laws were enacted, and if they are in conflict with another clause, that is Article 26 Clause B, the court adopted interpretation known as a harmonious construction was applied. this I'll deal with while dealing with Article 26, Clause B. And it has Article 25 is an individual religious, guarantees individual religious freedom. If a group wants to have religious freedom, then they have to look into Article 26, not in Article 25. Now, Article 25 contains two explanations also. Explanation 1 says that the right of a Sikh to carry a kirpan on his body is granted or is permitted. Kirpan is a lethal weapon. Without permission of the police, the lethal weapons are not to be carried on the public streets. Since it is a religious symbol for them, it is specifically provided in explanation 1 to Article 25. And explanation 2 says that the word Hindu includes Buddhist, Sikh and Jains. Buddhist places, religious places, Sikh religious places and Jain religious places can also be thrown open for the purpose of worship by the followers of Hindus. This explanation is confined to Clause 2B only. Article 25, Clause 2B only, this explanation is to be understood. Now, we'll go to Article 26. Article 26 contains only 3 grounds of restrictions, but not the 4th one. Other provisions of Part 3 of the Constitution is not there in Article 26. It contains only public order, morality and health. Subject to public order, morality and health, every religious denomination or any section thereof shall have the right to practice or exercise 4 kinds of rights. Right to establish and administer educational and charitable institutions and then right to manage its own affairs in the matters of religion, right to own and acquire movable property, right to own, acquire only, not dispose of. The power of alienation is not given to any religious denomination so far as the religious properties are concerned. They can acquire and hold, but not to dispose of. Fourthly, to administer such property in accordance with the law enacted by the legislative organ of the state. So how many provisions must be there in this law? What kind of safeguards must be there in this law is not mentioned here. The only thing is, religious properties may be misused. That is the reason why legislative power is given to the legislature to enact a law for regulating the religious property, but the right of administration must be given to the concerned religious denomination only. Then what is a denomination? The word denomination is not defined in the interpretation clause, Article 366. Consequently, it has to be understood what was mentioned in the dictionaries. Because if any word is not defined in the statute law, then we have to go to external aids to construction, where in dictionaries occupies the first place. So the Oxford Dictionary contains 3 elements for a denomination. A collection of individuals which are having common faith. Secondly, a specific organization. Thirdly, if it is have a distinctive name, then it is a denomination according to Oxford Dictionary. Following this, the Supreme Court in 1954 in Shirur case said that this definition must be applied for the purpose of denominations. Consequently, only these denominations must claim the rights but not individuals. So then, Acharya Jagadishwar Anand versus Police Commissioner Anand Marga case. In Shirur case, this definition was the definition of denomination as provided in the Oxford Dictionary was accepted by the Supreme Court. And then came this Anand Marga case, wherein the facts of this case were that you must be knowing about this. They were playing Tandava dance on the public streets by holding trishuls and all those things, human skulls. This was prohibited by the Calcutta Police Commission under the police regulations by imposing 144 section and all that. And the matter reached the Supreme Court. Elements are satisfied, then every religious group is bound to get the identification of religious denomination for the purpose of exercising rights under Article 26. Now, 26A, what it says? Right to establish and administer religious and charitable institutions. The word establish and administer must be read together because the word and is conjunctive but not disjunctive. The word and is there in between these two. End is a conjunctive, not disjunctive. Consequently, unless the concerned religious denomination establishes the institution, it has no right to claim the right of administration over it. In Aziz Basha versus Union of India case, AMU was not allowed to be administered by the concerned religious denomination because it was established under a central law known as the Aligarh Muslim University Act. So many number of eminent juries have criticized the judgment on the ground that though previously all these institutions were established by the concerned religious denomination, on a narrow technical ground, this judgment was given by the court. Consequently, many number of juries have not satisfied with the judgment, including H.M. Sherwa. He also criticized this. And so the word established and administered has to be interpreted for the purpose of claiming rights by the religious denominations. Another controversial issue is matters of religion. Right to manage its own affairs in matters of religion. Concerned religious denomination is having the right to manage its own affairs in matters of religion, what it is. What are the matters of religion? What are not the matters of religion? It is here, for the purpose of protecting the religious rights of the individuals in the society, the Supreme Court has devised a test known as Essential Religious Practice Test. This Essential Religious Practice Test, for the first time, it was laid down by the Supreme Court in 1954 itself in Shirur Mutt case. And after that, again when this case was, another case came to the Supreme Court known as Hanif Qureshi versus Bihar cow slaughter case, which is subjected to a lot of criticism by the jurists themselves. The court has accepted the fact that, as laid down in Shirur Mutt case, what is an essential religious practice means, it has to be decided by the concerned by consulting the concerned religious dictates, and no civil authority or outside authority has any right to say whether this is practice of religion or this is not an essential religious practice. So how they have to decide the case means, if this matter is placed before the court, then they have to go through the concerned religious texts and then decide as to what amounts to religious practice, essential religious practice. And when these cow slaughter laws were contested before the court has opened the religious book, and it finds on a Bakrid day, either a goat can be sacrificed, or a cow can be sacrificed, or a camel can be sacrificed. Since these laws prohibited cow slaughter, since optional religious practice is provided there, the people can go for optional religious practice. Accordingly, cow slaughter laws were upheld by the court. This is also subject to a lot of criticism. When optional religious practice is given, options must be chosen by the concerned followers of the religion. When you have to go with coconut, or you have to go with flowers only, or you have to carry with the fruits also, this is left to the concerned religious followers, not to the Supreme Court to decide or some other court to decide. This is also subject to a lot of criticism. And then this Tandava dance case. This Anand Marg is claimed that Tandava dance is an essential practice of the Anand Marg order. Consequently, we have to practice this. And accordingly, they argued before the court that the restrictions imposed by the Calcutta Police Commissioner are a violation of Article 26B. The difference between Article 25 and 26, so far as the restrictions, grounds of restrictions are concerned, subject to other provisions of Part 3 of the Constitution, is not there in Article 26. It is there in Article 25. When it is not there in Article 25, if any provision in Part 3 is inconsistent with Article 26, then the court is bound to follow the principle of harmonious construction for the purpose of deciding the case. Following this principle, the court said that the Anand Marga, at the time of inventing this Anand Marga order in 1955, it did not have any kind of Tandava dance or something else as an essential practice of Anand Marga order. Now they have opened the Anand Marga religious book known as Karya Karya, and it is found that it is not there in the book. Then the Supreme Court in 1983 said that this is not an essential religious practice of the Anand Marga order. So we are not, though we accept that this is a religious denomination, but this is not an essential religious, Tandava dance is not an essential religious practice of the Anand Marga order. Thereafter, wisely, Anand Marga amended the Karya, and then Tandava dance as an essential religious practice of the Anand Marga order was added to book only to circumvent the Supreme Court judgment of 1983. Again, they started the practicing this Tandava dance on the streets. Again, it was prohibited. Now, again, it reached the court. This time, the Calcutta Supreme Court said that, Calcutta High Court said that. It is there in the book. Consequently, Tandava dance is an essential religious practice. It cannot be taken away. The police commissioner went in appeal to the Supreme Court. There, the Supreme Court said that, so far as the legislature is concerned, inherent powers of the legislatures cannot be exercised by the religious bodies. For example, you have abrogative power. Abrogative power is something which has to be exercised only by the sovereign legislatures and not by the religious heads. For example, Rajiv Gandhi administration, nullifying Shabana case, enacted a law for only to nullify the Shabana case, known as Muslim Women Rights and Divorce Act. This is an abrogative power. Here the court, the religious institution has exercised this abrogative power. Thus, when matter was placed before the court said that religious institutions are not permitted to circumvent the judgments of the courts. Consequently, we are not going to accept this even amended version also, even though it is amended. Because if you start doing this, every religion amends the law. There are textbooks. And then ultimately, the religious textbook will be superior to the constitution. So we are not going to accept even this one. Accordingly, Tandava dance was held not an essential religious practice of the Anand Marga order, because the abrogative power of the legislatures must be preserved for the legislatures only and not for the religious institutions. Likewise, in Venkatramana Devaru versus Mysore, somewhere in 1958, a temple was established by Gauda Saraswati Brahmins. So they are managing the temple, they are conducting the puja and everything. When temple entry authorization law was enacted by the Mysore government, enabling the excluded sections for entering into the temples for worship, even excluded sections are also started entering into the temple for worship. So consequently, the temple authorities have, the denomination has argued that we are not going to permit you to enter into the temple because this is a denominational temple. Consequently, Hindu temple means some other temple but not denominational temples. Or any other temple does not include denominational temples. Consequently, denominational temples are different, and temples which are meant for general public purpose are different. You go into the temples in general public purpose, but not to the denominational temples. But here the court said that throwing open all the Hindu religious temples of public character means all the temples including denominational temples. Why the court said this means? There is a clash between Article 25(2)(b) with that of Article 26(b). Article 25 as such is subject to other provisions of Part 3 of the Constitution, the freedoms guaranteed by Article 25. Whereas the freedoms guaranteed by Article 26 are not subject to other provisions of the Constitution. Consequently, Article 26(b) cannot be subordinated to 25(2)(b). Both the provisions must be given effect to. And hence the court said that you exercise your power, you conduct pujas according to your tradition, and these people have also right to enter into the temple during the opening hours of the temple only. And the authorized pujari is allowed to conduct puja in the temple, and other people, people who are entering into the temple, they are not allowed to enter into the sanctum sanctorium and touch the idol. Only your achara, your pujaris must conduct the puja and touch the idol. These people will not enter into the sanctum sanctorium. In this way, both the provisions were given effect to. By the application of the principle of harmonious construction, the same was applied in Shastri Yagnapurus Dasi versus Muldas also. Here, some adverse comments are also made by renowned juries, whose names I do not want to reveal. The courts are entering into mythological issues. What amounts to Hinduism? In this Shastri Yagnapurus Das versus Muldas. Satsang is a group of individuals following Swami Narayana sect. They argued that Swami Narayana is not part of Hinduism. We have a separate religion. The word Hindu as provided in the word Hindu provided in explanation 2 to Article 25 means not Swami Narayana sect. It has to be excluded. And then Gajendra Gadkar, Justice Gajendra Gadkar, reviewed the Hindu philosophy and literature, including Swami Narayana sect's literature, and he came to know that those people were praising Lord Krishna. And then the court said that when Lord Krishna is worshipped, he is part of Hinduism, consequently you are Hindus, and I laid down who a Hindu is. And then he gave a three-pronged, three-element definition as of who a Hindu is. Reverence towards Vedas, means and salvation are many and varied. A number of gods to be worshipped are many and varied. This is the definition of Hinduism. Accordingly, this was accepted by the court. Accordingly, this case was decided, giving a permission for the excluded sections to enter into the temple for worship, for the purpose of worship only, but not to enter into the sanctum sanctorium. In this way, we have many number of things, including excommunication case also. As a religious study is having a power to excommunicate the individuals on the ground that they are not practicing religious practices, or they are renouncing the religion, or they are renouncing the world. Said so in excommunication case. So in this way, you have different areas, and most of these areas are controversial, and at the same time, it is necessary to decide these cases. Otherwise, we cannot blame the courts for the purpose of venturing into the theology of various religions, because it is a must for them to do so, as a religious freedom is guaranteed, or a religion, it governs the relation between man and God, but not between man and man. It always deals with the relation between man and God. That has to be accepted. Thank you very much for your patience.
Thank you, Professor Madhusudan Rao, for extensive talk on the guarantee, the religious practice guarantees under the Constitution and the Supreme Court pronouncements on those rights. As Professor Rao rightly said, the secularism means separation of religion from the state. He also said that there is a difference between Article 25 and 26. 25 is subject to the provisions of other parts of the Constitution, whereas the right to establish, manage, acquire religious institution is subject to the public morality, public order, etc., and it is not subject to other parts of the Constitution. But he also said that right to acquire does not mean right to the dispose of. But if it is right to manage, Professor Rao, how it would not also include right to dispose of if some property is dilapidated or it is no longer is required. So I would like his comments on this. So far as the Chittoor Mutt case is concerned, that is Keswanand Bharati case, the Supreme Court upheld the law laid down by the Kerala legislature to sealing laws, agrarian reforms, and the Mutt, which was having large extent of properties, were acquired by the state under that law, and that law was kept under the 9th schedule, so it became immune from challenge under Article 14, etc. But if it was the right guaranteed under Article 26 to manage, acquire, possess the properties, then if it was such a right, because there was no public morality involved in according the right by that religious sect or denomination, Chittoor Mutt, Keswanand famous Bharati case, but Supreme Court still said the state has power for betterment of the people to distribute the largest, the resources to acquire the property, and therefore that law was upheld, though it held that they laid down the basic structure doctrine. Justice Gajen Gatkar's the judgment in Swaminarayan sect, that when they are worshipping Lord Krishna is nothing but a god of Hinduism, and therefore you are not a separate religion. I think well laid down, but my point is that why the courts should go into these aspects, what is the essential practice or what is not an essential practice. If that practice does not come in conflict with the Article 14, 19 and 21, then that practice should be upheld. If it comes within the conflict of Article 14, 19 and 21, because Article 25 is subject to other provisions of the Constitution, then the court may strike down that it is not a essential, it is a practice which is coming in conflict with Article 14, 19 and 21, which is a golden triangle, then it may be essential or not essential. I think it should not, this is my view, this is my personal view. Unnecessarily going into this thing and court defining what is essential practice or what is not essential practice. The better way, in my understanding, is to that whether it comes with the conflict of Article 14, 19 and 21 or not. Yes.
The golden triangle is developed recently. When all these cases were decided in 1954, 58 and all those times, and in 1984, this golden triangle concept is not there. Under the Canadian Constitution, there is a concept known as the living tree. This concept in Indian Constitution, what we are calling it as transformative Constitution. In the course of transformation, certain principles previously applied, they can be modified by the courts also, because these principles are applied by the courts. Let the courts modify them consistent with the later developments in the spheres. Secondly, religion as such is a freedom guaranteed by the Constitution. If essential religious practice is not taken into account, the purpose of providing Article 25 and 26 will be defeated. That should not be the interpretation of any provision, including constitutional provision. First, you have to save the freedom of religion, first of all. For saving the freedom of religion, for example, idol worship. Idol worship is the Hindu religious practice. Accordingly, it is an essential religious practice. We cannot deny this fact. If idol worship is taken away, what kind of practice that remains there, so far as the Hindus are concerned? So it is this kind of the controversy the court has faced, because the courts are sentinels on the QI. They have to protect the rights of the individuals. So accordingly, they evolved this test known as the essential religious practice test. There are people who criticized this test also. You go according to subject, public order and health and other provisions of Part 3 of the Constitution, and you decide the case. If you take only these things into consideration without looking into the essentialities of any religion, then religious practice cannot survive in the country. But that is the object for which, that is not the object for which the religious provisions are provided in the Constitution, or religious freedom is provided in the Constitution. That's my opinion.
I will request now Professor Archana Ranka to give her speech.
Good afternoon to the session chair, Honorable Justice Dinesh Kumar Singh, Judge, Kerala High Court, session co-chair, Professor K. Madhusudan Rao, Professor at Andhra University, and Justice Agrawal, Honorable Vice Chancellors of University, all dignitaries, my colleagues present of the dais. In today's topic, as we know, India is a land of varied cultures, and it consists of different beliefs and different religions. Now, as my co-chair has already talked about the religious test, that is essential religious practices test, which was established by the Supreme Court in various cases. So I will not cover this topic. Now when we see the International Covenant on Civil and Political Rights, its Article 18 guarantees the right to freedom of thought, conscience and religion. It is also an inalienable human right that gives an individual the liberty to worship the God of his choice. India guarantees the religious freedom as fundamental right by virtue of Part 3 of Indian Constitution, as Sir has already covered Article 25 to 28. Now when we see the survey that 79.8% of India's overall population belongs to Hindu religion, and 14.2 belongs to Muslim community, and around about 6% of population belongs to Christian, Sikh, Buddhist and Jain. So Hindus make up large majority of the population in our country. But Hinduism is not accorded a specific place in the society as per our constitution. In India, lack of state religion provides equal opportunity, recognition and protection to all religion. But because of various hurdles that exist in the country, it becomes difficult to practice religious freedoms, and all these hurdles became an immense threat to the secular structure of the country. Despite the fact that the word secularism is added to the Constitution, it is not being able to be accepted in its true sense. India is a land of varied culture and diversity, and India has no official religion and guarantees freedom of religion through various fundamental rights. However, all that have not achieved the desired results. The gap is ever-ranging, and despite all the guarantee and framework, it is still a distant dream to achieve the true intent of the word enshrined in our Constitution. There are varied reasons behind it, like party politics, communalism, religious fanaticism that still pose a threat to achieving the goal of secularism. Because of certain political, cultural, and religious hurdles that exist in India, secularism and freedom of religion have not been given much importance because of varied conditions that exist in various parts of our country. Secularism in India only exists in formal sense and not in its substantive sense. The challenges to Indian secularism are complex. They can be listed and discussed as communalism, casteism, party politics, and obscurantism. It is already from the previous discussion, some constitutional provisions are also contrary to the principles of secularism. As per the nature of society in India, which is based on traditional, religious, and social values, the challenges to secularism need to be tackled by measures like constitutional amendments. The secularization of Indian society and modernization in every sphere of life is to be taken care of. This task is not to be left to the government alone. It requires everybody's effort and cooperation from all. Justice Gajendra Karkar observed that the plant of secularism is a very delicate plant, and it has to grow on the Indian soil. It must be watered and tenderly nursed by all secularists in the country with care and dedication. It is hands of faith that are needed for the achievement of this task. And these hands of faith must be supplied by the intellectuals of today. In order to solve the problems of secularism in India, education without a secular bias can play an effective and valuable role. For this, education must be controlled by the state and completely separated from the religion. To solve the problem of communalism, it has been suggested that the Indian government should introduce a course of comparative religion as a part of educational curriculum at the secondary stage. As we know that India is a multi-religious, multi-caste, multi-racial, and multilingual country. In this situation, the majority group has a great responsibility to induce security and confidence amongst the minorities. And the minorities too cannot evade their responsibility to be cooperative with the majority. It has been argued that a secular state demands that while the majority is tolerant and accommodative, the minority in turn should reciprocate and avoid alienation and segregation. Indian secularism needs a society with the people having a secular attitude towards the solution of economic, social, and political problems facing the nation. There is a need to accept secularism as social philosophy and as a way of life. The concept of secularism as embodied in the Constitution of India is the product of India's own political, social, and religious condition, and it is to be implemented in the society which is full of diversity and which is basically religious. The majority of the people of India are superstitious and obscurantist. In India, there are many castes and religions which have been exploited by the politicians of different political parties after the independence of India. As a result of this, Indian secularism is confronted with many challenges. So, to conclude, it would be fair to say that secularism is of great significance in view of India's social, economical, and political framework. Secularism can meet the demands of a multi-religious, multicultural, and multi-class and multilingual society like India. Secularism is essential for fostering ties between people of different communities in India. It seems to be the most effective cementing force in this context. The concept of secularism is also relevant to the process of nation building. Its increased influence will eradicate communalism and sectarianism from the country. It is a powerful antidote against communal conflict in the country. Secularism is also important from the point of view of enjoying fundamental rights which are conferred by the Indian Constitution. The answer to the challenges to Indian secularism and the inconsistencies in it can be found in building up a secular society in India. It means that society will be based on secular values of life, and the social life and the institution in the society will be free from hold of religion. There is also need to amend the constitution so as to make it more secular in character. For this, the government should make a policy to advocate for secular ideals in education. Religion-related matters should not be brought up in the discharge of public duty by any government official or political leaders. To eliminate ambiguity and provide a clear understanding of the term secularism, it should be defined in the Constitution or a specific article defining the true character of India as a secular state should be added. It is necessary to promulgate uniform civil code. Strong laws must be passed to ensure fair trials and quick conviction in cases of rioting, hate crimes, and racial biases. It is also essential to accept the concept of secularism as a social philosophy rather than as a mere political ideology. For this, the state should strive to create awareness among the people through education. Government attitude and behavior should promote industrialization and economic growth, which could eradicate fundamentalism and communalism. Therefore, the secular constitution and the state are not sufficient to uphold secularism in India. A secular environment is required. The idea of secularism, which is inscribed in the Indian Constitution, would only exist as a philosophical and constitutional term in the absence of secular society. Thank you for your patient hearing.
Thank you, Madam Archana Ranka, for your thought-provoking speech. You said concept of secularism does not, in fact, pervade in the society in practice, but only in formal sense. The secularism has to be a way of life and not only a textual context. She further said that education must be secular. Article 29 guarantees the establishment of the institution by the religious and linguistic minority where they have right to impart the religious texts and instructions. When the Constitution itself guarantees right of establishment of educational institution which can impart the religion and religious text. I mean, is it possible to say that the education must be complete secular? Then the Constitution has to be amended. That right has to be taken away from the minority and linguistic minorities. Then madrasas have to close down. One of the judgments, one of the order I said that India being a secular state, why it is providing the government aid, taxpayer money to the educational institutions which are imparting the instructions. I don't know what happened to that judgment. Thereafter, I was transferred, so final is not known to me. But the society is basically the secular society. Here it has been Sarv Dharm Sambhav, Vasdhaiv Kutumbakam, Kirvante Vishwar Maryam. These have been ingrained in the society. It's not the recent phenomena or recent concept. The Indian society has never discriminated a person on the ground of religion. It has welcomed all. If you see the ancient history, it has welcomed all religion. Those who did not get accommodation elsewhere, they got accommodation here. Whether it's Jews, where they were. And therefore, Iqbal, though he was initially he was a nationalist, then he became Pakistanist, and he said in his famous poem, Sare Jahan Se Acha Hindustan Hamara. ईरान मिस्र रोमा सब मिट गए जहाँ से कुछ बात है कि हस्ती मिटती नहीं हमारी. What is this hasti? This is the ethos. This is which is ingrained in Indian society, tolerance, sarvdham sambhav. So the majority, I don't think it is a fundamentalist. There has to be difference between fundamentalism and being religious. You may be religious, you may be going to temple every day, you may be performing puja, but you will tolerate others also performing puja. This is the secular character of the society. That you don't interfere with the other person's religious belief and practices, so long they don't interfere with you. And you allow everybody to practice their own religion, and we have done it. I went to, there is a Fort Kochi where there is a Jewish settlement today also. So it is not that majority is here against this concept. The secularism concept, according to me, is that state should keep its hands from the religious matters so long they come in conflict with the fundamental rights of other citizens. public order, morality, and law and order, other situations. In Uttar Pradesh, recently the government said that nobody will perform namaz on Eid, on road, rightly so. I don't think that there was anything wrong, and no court interfered also. Because it is coming with the public order. If you are occupying the roads which are meant for commuting and you occupy the road, it comes within the power of the state to regulate that. Therefore, to say that the secularism has to be way of life, it is a way of life in India. It is not against the way of life. Now I will keep the floor open for questions and discussion.
Sir, I want to say something, that education to respect the other's religion, it may be minor, it may be major, that was my point of view, not educational institutions, sir. Thank you.
I'm a religious person, and recently, just 3 days back, I completed one component of my unit, that is the religion line secularism in India, as part of Indian society and culture. Okay. So, what is my question? I am a religious person. But my religion never says that don't respect others, don't believe in others. That's what I understand. So, rather than talking about being secular or non-secular or secular, what do you take on that? Because I'm a religious person. I don't talk about the secular, non-secular, and that will no way bother me to discuss about the religion. You know, when I'm talking to any nearby mosque or Gurdwara church, I automatically go down there, thinking that belongs to God. I say I'm religious. My religion only with respect to others. This is my question. Please.
Means you are an aesthetic person, that you want to say? What is your question, sir? I can't. You respect all religion, that is your question.
He said, I am a religious person, but I respect all other religion. Then can I not be said I am a secular? If I am practicing my own religion, if I am not interfering with somebody else's religion, can I not be said to be secular? This is his fundamental question. Am I correct, Mr. Singh?
So, you are following your religion and you are respecting other religion also. That is your question. So you are respecting others' religion and you are following your religion, so that is also comes within secular.
Which provision is prohibiting you from calling a secularist? You are a religious person, you are giving respect to other religions. Then which provision is calling you as you should not be religious? Are you at the same time secular? Why not? Is there any provision saying that all religious persons should be extremely religious or fundamentalist and they should not be secular? Your outlook can be secular. What is wrong with that? Huh? Where is the doubt? What is wrong with that? Your outlook can be secular. You can practice your own religion. That's the reason why D. Smith said, secular state, all the secular state means there should be no religion to the state. State will not patronize any religion. State treats the individual as individual without religion, religious color. That is the only thing required. You can be a secular and you can be a thorough religiosity. You can have thorough religiosity. No objection is there for you.
I'll clarify. Please understand, the secularism is not for the individual, it is for the state. This concept is for the state, that the state will not have a religion when it is administering. It will not govern the religious affairs of the people. This is not for the person that you should be secular. You may practice your religion. Nobody is asking you not to practice this. In fact, it is guarantees under Article 25 to 28 to practice your religion. The secularism concept is for the state. The state will, when it is administering, laying the law, it will observe equal distance from all religion. It will not propagate or promote any particular religion. So this is, you may be religious, there is nothing wrong in it, because the Constitution itself guarantees to practice your own religion. So secularism, which is not for individual citizen, it is for the state, one. Second, that as you said, that I respect all religion, this is in ethos of this country, that we have always respected all people of all faith. So far, they have not interfered with us. They have not, converted us by force, the allurement or other things. So we have never objected somebody coming. In fact, we have welcomed all religion, all people from all over world. So that I said that sare jahan se acha, what is this? What is continuing? This is this culture. This is this ethos. This is being Indian, which has been continued.
Thank you so much, Lordship. Such a great points which has come from this panel. Now, my name is Amit Pratap Singh. I'm a faculty member at NLIU Bhopal. States should not promote or go forward to any particular religious view or one particular religion. But when we look at the kind of subsidies which are coming to promote certain religious activities, where state gives certain finance or funding in the form of certain subsidies, without taking or pointing out any religious view or any particular religion involved here. The other part of the same question is that when government itself uses the money which is coming from certain endowments or temples, which are necessarily religious in nature, if state is not doing anything, then it should not use it also, both the way. But then state does it. How is that even possible in the constitutional framework which we have, my lord?
I understand where you are hitting the... that it is more prevalent in Kerala, where all the big temples, there are, I think 6, 7, the boards, Devsam board, Travancore Devsam board, there is Cochin Devsam board, there is a Malabar Devsam board, there is Guruvayur Devsam board, there is Devsam boards. And last figure, this January month, the Swami Ayappa temple, where I was there, lakhs and lakhs devotees go there. And the handsome amount is earned by Devsam board. If this amount is spent for the Shraddhalu or the devotees who are coming, nothing wrong in it. But unfortunately, if you go to the temple, you will find that the devotees, day before yesterday I was there, they are still sleeping on the floor, there are no facilities. Last year income was around 300 crores itself for that temple. But I don't know, nobody has challenged for me these acts, so I am not able to comment on this. But I agree with you that when the state is secular state, then why it is interfering in the management of the affairs of one particular religious institution? I completely agree with you that the state should not. interfere with the management of the affairs of the particular religion or any religion. Either you manage the affairs of every religion, and if you are, if suppose the committee or the trust is not properly managing, you can take over, but spend that money for the welfare of the devotees who are that temple or that institution. That is not happening. You are right. Yes. Another example is the richest temple, Tirumala.
The Constitution designed the state in India as not an irreligious state. It is not an anti-religious state. It is not an irreligious state. State in India helps the individuals to pursue their religious freedom. Every religion and every religious followers are taking this. Many number of cases are also decided by the Indian Supreme Court. For example, Hajj pilgrim case. And then in the same judgment, the Supreme Court commented that when you are spending money for providing security at that Srinagar temple, Shiva temple in Srinagar, what is that temple, Shiva? Huh? Amarnath temple, lot of security you are providing at state cost only. You are enabling the pilgrims to have their darshan. When you are spending there, why not you spend here in a Hajj pilgrim case or Hajj pilgrim issue? This is the comment made by the judge in this case. So the substance of this matter is, the state in India is not irreligious. It is not anti-religious. Secularism means not anti-religious. That both the things are clearly laid down in the Constitution itself. Consequently, the courts are also following the same. Thank you.
Hello, sir. My appellation is Sahil Samdaria from Sage University, Bhopal. Sir, we talk about secularism, but what is happening in Kabaddi totally different. Why is it happening that we are seeing such kind of instances where the person who are holding different kind of constitutional posts are deliberately allowing their ideology and their faith to dominate their constitutional duties? What is the reason behind that? The person who are holding different kind of constitutional posts are allowing their constitutional duties to be dominated by their ideologies and faith. Why is it happening? What we are still lacking in this country? Because we have seen lot of instances in the past years in almost every walk of life.
You tell me one instance so that I can understand it.
The statement given by the police officer in UP against the particular community, then you can't go on this day out of the, like this.
Mistakes committed by one or other official of the government is not the policy of the government. If any mistake is committed by one or other official in the government, it is not the policy of the state or policy of the government or policy of the constitution. So you cannot attribute this thing to the entire state, number one. Number two, if any state authority supported this kind of activity, then only you can question it. If one particular individual commits the same, he is subject to disciplinary action.
With that, we mark the end of our session on the Supreme Court and religious rights. We thank Honorable Justice Dinesh Kumar Singh, Professor Madhusudhana Rao, and Professor Archana Ranka for sharing their insights today and answering all the questions. Thank you, sir and ma'am. All the students are requested to be seated while the panelists and dignitaries move to the visitors' room for lunch. All the students are requested to please remain seated. Students will be notified as to when the lunch is being served. As for now, please remain seated.
A very good afternoon. A kind request to please occupy the front seats first. We will begin shortly. I request the audience members seated at the back to please occupy the seats at front first. A very good afternoon to all the dignitaries that are present here. My name is Arushi Rajagopala. I'm a third year student and I am privileged to welcome you all to this session. First and foremost, I invite our distinguished dignitaries for the session to kindly grace the stage. We have the privilege of having with us today Honorable Mr. Justice S.R. Banur Mutt Sir, former Chief Justice of the Kerala High Court, Professor Dr. S. Surya Prakash Sir, Vice Chancellor, NLIU Bhopal, Professor Dr. V. Vijay Kumar Sir, former Vice Chancellor of NLIU Bhopal, Professor Dr. Mona Purohit Ma'am, Head and Dean, Faculty of Law, Barkatullah University, Bhopal, and Mr. Siddharth R. Gupta Sir, Advocate, Supreme Court of India. As a token of our appreciation, we would like to felicitate all of our panelists with a miniature statue of Raja Bhoj, along with a handmade shawl. I would like to request our Honorable Vice Chancellor, Professor Dr. S. Surya Prakash Sir, to kindly felicitate Honorable Mr. Justice S.R. Banur Mutt Sir. Now, I would like to request Honorable Vice Chancellor Sir to kindly felicitate Professor Dr. V. Vijay Kumar Sir. Now I request Honorable Vice Chancellor Sir to kindly felicitate Professor Dr. Mona Purohit Ma'am. Now I request Honorable Vice Chancellor Sir to kindly felicitate Mr. Siddharth R. Gupta. I now request Mr. Yashpal Jhakad, President of the Student Bar Association of NLIU Bhopal, to felicitate Honorable Vice Chancellor of NLIU, Professor Dr. S. Surya Prakash Sir. Once again, I welcome you all to the final session of the first NLIU SBA Law Conclave 2025. This session contains a special podcast on an ever-important topic, the Supreme Court and the evolving dimensions of the right to life. For a topic as important as this, we have a truly expert panel, and it is my privilege to speak a few words about each of them. As the chair for this session, we are honored to have with us Honorable Mr. Justice S.R. Banur Mutt Sir, former Chief Justice of the Kerala High Court. Sir's journey is one that is truly inspiring. Having graduated from the prestigious Raja Lakham Gowda Law College in Belgaum, Sir rose very quickly amongst the ranks and was appointed by the government of Karnataka as the state public prosecutor in the year 1994. In June 1997, Sir was elevated as a judge of the High Court of Karnataka. Sir was also the founder president of the Bangalore Mediation Center during this time, and in that capacity was invited to the United States of America by the Justice Department of America to have discussions with major corporations. In the year 2009, Sir was elevated as the Chief Justice of the Kerala High Court, and later, in the year 2013, Sir was appointed as the chairperson of the Maharashtra State Human Rights Commission. During his time in the High Courts of Karnataka and Kerala, Sir delivered a great number of judgments and has contributed greatly to the jurisprudence surrounding death penalty in India, including through the case of the notorious Swami Shraddhananda. Sir, we are incredibly grateful to have you here with us today. Thank you very much. Now, it is my privilege to introduce the next distinguished panelist for today, Professor Dr. S. Surya Prakash Sir, Vice Chancellor of NLIU Bhopal. Sir is an eminent visionary and has previously served as the founder Vice Chancellor of MNLU Aurangabad and Vice Chancellor of DSNLU Vishakhapatnam. With over 30 years of experience in legal academia, Sir specializes in labor and industrial law, for which he was awarded the V.N. Dikshitilu Prize for Academic Excellence. A prolific author, Sir has written extensively on issues like bonded labor, arbitration, mediation, and legal education. Further, Sir was invited to the US under the prestigious International Visitor Leadership Program to study the American judicial system, and his interests include jurisprudence, ADR, labor law, and health law. Sir, we are eagerly looking forward to hearing your thoughts today. Thank you very much. We also have the good fortune of having with us today Professor Dr. V. Vijay Kumar Sir, former Vice Chancellor of NLIU Bhopal. Sir is truly a veteran academician with extensive experience in legal education. His journey as a legal academician began from the year 1988 when he began teaching at the National Law School of India University in Bangalore. He later held the UNHCR Chair on Refugee Law at NLSIU and subsequently served as the Registrar of NLSIU as well. Thereafter, Sir was appointed as the Vice Chancellor of Dr. Ambedkar Law University, Chennai from the year 2010 to 2013. Apart from his incredible administrative feats, Sir is also a brilliant professor. His areas of expertise include human rights law, refugee and humanitarian law, and of course, constitutional law. He has published more than 47 articles in both national and international journals and has contributed to the publication of 2 books as well. He has been a visiting scholar at York University in Toronto, Canada, at its Center for Refugee Studies. He has been awarded the Amity Academic Excellence Award and the Best Vice Chancellor's Award by the Indian Red Cross Society. Sir, it is truly wonderful to have you back here with us, and we're eagerly looking forward to your insights on the topic for discussion today. Next, we are grateful to have with us today Professor Dr. Mona Purohit Ma'am, Head and Dean, Faculty of Law, Barkatullah University, Bhopal. Ma'am is an accomplished academician with over 2 decades of teaching experience. Her areas of expertise span cyber law, environmental law, public laws, IPR, and modern legal studies. Ma'am has authored 2 books and published over 30 research papers in reputed journals. Under her guidance, 14 scholars have completed their PhD and over 200 LLM dissertations have been awarded. She has also worked as a consultant on key legal projects with the UNFPA and NLIU Bhopal and has conducted training for governmental institutions as well. She has received multiple awards including the Sahitya Shiksha Ratan, Seva Samman and Best Teacher Award. Ma'am's commitment to legal education through programs on radio and television continues to inspire students and legal professionals alike. Ma'am, we are deeply and truly thankful to have you here with us today. We are also grateful to have with us Mr. Siddharth R. Gupta, a graduate of NLIU Bhopal, batch of 2006. Sir is a practicing advocate at the Supreme Court of India. Sir began his legal career under the guidance of Mr. Vivek Tankha, senior advocate and seasoned parliamentarian. Over the years, Sir has handled a wide range of matters, including real estate, education, taxation, service law, and arbitration. He was also the standing counsel for the High Court of Madhya Pradesh establishment for almost 4 years, representing the High Court as a party before various courts. He shifted his practice entirely from the High Court to the Supreme Court in the year 2022, after practicing in the High Court for almost 15 years. Sir is also one of the founding members of the CAN Foundation, a pan-India initiative dedicated to making legal education and legal profession accessible to the financially challenged candidates undertaking law. Sir, we are truly honored to have you here with us. Now, I request the chair for this session, Honorable Mr. Justice S.R. Banurmat, sir, to take over the session.
Professor Vijay Kumar, former Vice Chancellor of NLIU, Dr. and Professor Surya Prakash ji, Brother Judge Justice Dinesh, Professor Mona, Siddharth, the Professor Venkat Rao, and all the dignitaries present, academicians, and most importantly, my dear law students who are aspiring to be advocates, both litigation and corporate, or judge, or IAS, IAPS officer, or simply a law graduate. Today, I am addressing on a very important topic, that's Supreme Court and evolving dimensions of right to life. Today, this conclave is about the Supreme Court and various aspects it has dealt for the last 2 days. And as the right to life arises and the Supreme Court's jurisdiction existence arises from the Constitution, little bit about interesting facts about Constitution coming into existence as we are celebrating 75 years, and then to introduction to the fundamental rights and especially Article 21. This is what I propose to do. The Constitution of India is one of the most monumental document. As we know, India is a country of nearly 143.81 crore population with diversity in religion, language, food, culture, geographical structure, etc., making us one of the most unparalleled land of the earth. Now, every religion has its own holy scriptures. Bhagavad Gita and Veda for Hindus, Quran-e-Sharif for Muslims, Bible for Christians, and Guru Granth Sahib for Sikh people. But the only holy scripture which binds us all and unifies is the Constitution of India. Dr. Rajendra Prasad, the first president, said, I quote, "The Constitution of India is not a mere book or a document. It is a vehicle of life, and its spirit is always the spirit of the age." The Constitution of India acts
as the supreme legal document which binds all the three wings, legislative, executive, and judicial. It defines the framework of the Indian government, outlines its powers and responsibilities of different government bodies, and ensures a system of governance based on the principles of justice, liberty, equality, and fraternity, safeguarding the citizens' fundamental rights. It essentially provides for a stable and structural system for the country to be governed by itself, as we have given the Constitution to ourselves. While celebrating this 75 years of the Constitution, we must proudly remember Sir Benegal Narsingh Rao, who was then the ICS officer, today equivalent to IS, during British regime, who later became the judge of the Bengal High Court, first Indian judge in International Court of Justice, and president of the United Nations Security Council. It was he who prepared the draft of the Constitution by literally studying more than 60 constitutions in the world. Now, this draft was ultimately placed before a committee, Constitution Assembly, which consisted of 7 members. Dr. Babasaheb Ambedkar was the chairman, then Shri K. M. Munshi, Alladi Ramaswamy, N. Gopal Swamy, N. Madhavrao, T. Krishnamachari, and Mahmudullah Sadaullah. And this assembly took nearly 3 years to prepare the final draft of this Constitution. Finally, after 186 days, on 26th November 1949, the Constitution was formally adopted. And in remembrance of this historic event, we celebrate 26th November as the Constitution Day. And it came into force effect on 26th January 1950. As you know, it is a Republic Day. Now, there are very interesting facts about the Constitution itself, the document itself. It is the lengthiest written constitution in the world, containing nearly 1.5 lakh words in English version. The original Constitution was neither printed nor typed. It is handwritten. The English version was written in the flowering italics by a calligrapher known as Shri Prem Narayan Raizada, and Hindi version by Shri Vasant Vaidya. The two original versions, handwritten, one in English and another in Hindi, are today kept in special helium-filled glass cases in the Central Library of Parliament. It consists, each English version especially, consists of 234 thick pages and weighs nearly 4 kilograms. The preamble was designed by Shri Ram Manohar Sinha, and each page of the entire Constitution is decorated with miniature paintings on the border sides, designed by one of the most famous painter, Shri Nandalal Bose of Shantiniketan. Now, this Constitution is always referred to as the living document because it is both rigid and flexible, as some parts of it cannot be amended and some can be amended in certain parts. The Constitution of India is also known as the bag of borrowers, as many provisions are borrowed from the constitutions of nearly 60 countries like USA, UK, Ireland, France, Canada, Australia, and Soviet Union, as well as South Africa and Japan. Now, more than 2,500 amendments were carried out at the draft stage itself. And this is the only document where on 24th January 1950, 300 members have signed, of the Constitutional Assembly, have signed all the pages and last page of the document. And every page is signed by, permitted to be signed by the calligrapher. Today, I'm not going to speak on the Constitution in detail or on structure or various articles. It will take days together to speak on each article, and even to speak on preamble, it will take many, many days. Today, I'm focusing only on one article, that is Article 21 of the Constitution of India. Since it is the part of Chapter 3 of the Constitution, which consists of fundamental rights, little bit about fundamental rights, and then I will come back to Article 21 itself. Now, the fundamental rights play a pivotal role in upholding the principles of democracy. They establish a balance of power between the state and its citizens, preventing potential abuses of power by the authorities. The fundamental rights are inherent, inalienable, and designed to uphold individual dignity and collective welfare of the Indian society. They act as a limitation on the state power, ensuring a fine balance between the authority and the freedom of individuals. Now, fundamental rights are mainly meant to be protecting the citizens' liberty, dignity, and ensuring social justice, what we claimed in the preamble of our Constitution itself. It is to be noted, merely declaring fundamental rights in the Constitution would not have achieved the purpose unless remedial measures in case of their violations are provided. Shri K. Munshi, one of the members of the Constitution Final Assembling Authority Committee, wrote, "Rights are real only if they are accompanied by remedies. It is no use giving rights if an aggrieved person has no legal remedy to which he can resort when his rights are invaded." Now, to protect these fundamental rights, the Constitution makers entrusted the duty to the constitutional courts, namely the Supreme Court and High Courts of various states. As I said, law is neither static nor stagnant, but it must always be flowing or molding in contextual circumstances or changed circumstances. Now, to keep the balance between balance and check, the Supreme Court of India have carried out this sacrosanct duty of protection of the human or fundamental rights, exercising the powers under Article 32 or 226. And I can say, without fear of contradiction, that the constitutional courts are the saviors of our fundamental or human rights by interpreting and molding the fundamental human rights jurisprudence. Now, at the heart of these fundamental rights guaranteed to us are all important, but in my view, Article 21, right to life, can be called as mother of all fundamental rights. It must be mentioned that Supreme Court of India has displayed remarkable craftsmanship through its various judgments to analyze, promote, and protect fundamental rights, And this is more evident from the fact that Article 21 has been interpreted from time to time and newer interpretation every time case comes before it. Now, Article 21, which is known as fundamental right to life, reads thus: no person shall be deprived of his life or personal liberty except according to procedure established by law. Now, initially it appears this right was confined to arrest and the rights of the prisoners. This was by looking into bare reading of this provision. Now, we have to look into few words in this provision. The phraseology of Article 21 starts with no person. This word no is to be considered along with the word provided. A person, deprived. No person is connected with the deprived. And the basic object of this right is to prevent encroachment upon the personal liberty of individuals. Now, another word, important word in this is word used is person. Everywhere, most of the places, it is a citizen. So it means that whether you are Indian or not, citizen of India or not, this right of life is available to you, to the person. Now, it is to be, why this provision was originally made? It is to be remembered, arrest of a person is vital to prevent and protect an society. But at the same time, his freedom is also to be protected. There is no dispute that activities of hardcore criminal needs to be curtailed or kept in check by arresting and detaining him in prisons. But it is not necessary that liberty of a person should be taken away on flimsy grounds. Arresting a person who is not required by the law is equally bad as leaving an offender free. As such, there is need to be balance of conflicting interests, as the liberty of the prisoner or accused to be arrested is also involved. Now, from reading of the earlier judgments of the Supreme Court on Article 21, it appears the Supreme Court was of the view that this article is confined to arrests and in respect of the accused of a crime. And they were somewhat hesitant in broader interpretation of this word. Now, this is clear from a famous case, A.K. Gopalan versus State of Madras, where it was argued that in the case Article 21 along with 19 has to be considered. And the Supreme Court observed Article 21 gets attached only in case of deprivation, in the sense of total loss of liberty, and that article has no application in cases of restriction upon the right to free movement. Now, in this case, the court was applying the doctrine of procedure established by law. This doctrine emphasized strict or literal adherence to legislative procedure without questioning its fairness. However, the perspective underwent a transforming change in the landmark judgment of Maneka Gandhi, wherein the Supreme Court itself ruled that Article 14, 19, and 21 of the Constitution are interconnected and must be read together. The court emphasized that the interplay of Article 14, 19, 21 ensures that personal liberty, equality, and fundamental freedoms are safeguarded against the arbitrary action of the state. Together, they form a robust framework protecting individuals from excessive executive power and ensuring justice, fairness, and equality in governance. Thus, the earlier consideration of procedure established by law now came to be changed by elevating the meaning given to due process of law. Now, due process of law, the courts primarily examine whether the law in question has been followed irrespective of whether the same is just or reasonable. The judiciary does not assess the fairness or reasonableness of the law, and as such, under this doctrine, its role was limited to ensuring procedural compliance. However, in the case of due process of law, courts assess whether the law that restricts life or liberty is also just and fair and reasonable. Both the substance of the law and the procedure prescribed by it are subject to judicial scrutiny. Now, this doctrine provided broader protection to individual rights by ensuring that the law respects the principles of justice and equality, and it prevents arbitrary or oppressive laws from being enforced. After 3 decades rather, later in the case of Maneka Gandhi, as I was mentioning, the earlier view taken in Gopalan's case was rejected, stating that the procedure which can deprive a person of his liberty or life under Article 21 must be right, just, and fair. Thus, the new principle of doctrine of due process of law was also continued. Now, in that case, it was specifically mentioned, I quote, that life includes all those aspects of life which go to make a man's life meaningful, complete, and worth living. Now, that is the theological meaning given to the word procedure in Article 21, thus converting procedure established by law into due process of law, which can stand the test of fairness and reasonableness. Now, as stated, initially, though very limited meaning was given to this article, confining it to only the liberty and freedom of the accused. In the case of Kharak Singh versus State of UP, this view was modified by saying that Article 21 would require proper authority of law even for restriction on personal liberty. The meaning of word deprived was expanded in the case of Ram Sharan versus Union of India by holding that to constitute the ingredients of deprived, there must be some direct and tangible act which threatens the feeling of a person or member of a committee. Now, this was further expanded by the Supreme Court in case of Kiran versus State. It said, it does not mean that the court is helpless to interfere when there is an imminent threat to freedom of life and liberty, and the court must not wait till actual deprivation of place. As per the various pronouncements, as I said, the earlier judgments were in respect of the accused or prisoners. But in the case of Francis Mullin versus Union Territory, Delhi, it was held that the word life could not be restricted to the mere animal existence or mere physical survival. The right to life means the right to live with dignity. And this is the true interpretation of Article 21. Now, incidentally, it is to be noted that in 1980, the Supreme Court took a path-breaking step by breaking away from insisting on the principles of locus standi. Until then, the higher judiciary was insisting that in order to get a remedy from the courts, especially in the case of violations of human rights, the person approaching the court must be the actual victim or actually the aggrieved person. It was Justice Bhagavati and Justice Krishna Iyer who proposed the first principle which came to change the course of the judicial delivery system by entertaining what is called as public interest litigation, or as Professor Bakshi says, social action litigation. Of course, unfortunately, in the present days, there are a lot of comments on this PIL. It is sometimes sarcastically called as paisa vasool litigation or publicity interested litigation. With that, it can be stated that through the public interest litigation, many of the landmark judgments in respect of Article 21, expanding its scope, came to be in the judiciary field. In my view, in this process, the Supreme Court evolved from being a positivist institution to an activist institution by 20th century. And I always say that when it comes to Article 21, the judiciary has not only been involved in judicial activism, but also demonstrated enormous judicial creativity also. As I said, the earlier judgments before new expansion was given were like right to fair trial, A.R. Anthule case, right against handcuffing, right against solitary confinement, right to challenge the lengthy detention, right of appeal, extension of benefit to the co-accused, etc. These were all confined to the limited scope earlier interpreted by the Supreme Court. And at this stage only, I would mention one landmark judgment came, which is often referred to as the D.K. Basu case, wherein the Supreme Court laid down 11 guiding principles when person is to be arrested, what steps are to be taken. They are practically known as 11 commandments. These guidelines mandated towards protection of human rights, who are to be arrested and detained. There are hundreds of judgments on Article 21, but today I am citing very few important and path-breaking judgments as per my assessment as a judge of some standing. The first case is Francis Corelli versus Union Territory of India. Supreme Court articulated that the right to life includes access to basic necessities such as adequate nutrition, clothing, shelter, and opportunities for self-expression. It was emphasized by Justice Bhagavati that a dignified life involves freedom to interact with society and the capacity to express oneself completely. This case is an example of demonstrating human dignity is not a privilege, but a right intrinsic itself. In Bandhu Mukti Morcha case, it was stated that Article 21 is the heart of fundamental rights, deriving strength from directive principles of the state policy. In this case, it was emphasized that the dignified life must include protection of workers from exploitation, health safeguards, educational opportunities, human work conditions, and maternity leave also. In People's Union for Democratic Rights versus Union of India, the Apex Court held that labor laws intended to protect basic human dignity, and they were part of right to life. And as such, non-payment of minimum wages to the workers was deemed to be violation of Article 21. In Chandra Raja Kumar versus Police Commissioner Hyderabad, the court ruled that any activity grossly indecent, obscene, or intended for exploitation is repugnant to human dignity and violative of articles. Now, in the landmark judgment in Navtej Singh Johar versus Union of India, the Supreme Court considered the old provisions of Section 377, that is, which criminalized the consensual sexual act between man and woman. And it was held that it was violative of Article 14. In the case of Chameli Singh versus State of Uttar Pradesh, which was in respect of acquisition of land by government for public purpose, adversely affecting the livelihood of a landowner, the Supreme Court specifically observed that such acquisitions for the public purpose do not violate Article 21. This judgment related while right to livelihood is crucial, it is not absolute and must be balanced with public interest. Of course, many times the famous case of Vishakha is repeatedly quoted, which is in respect of protection of working women at her place, sexual harassment at her place. Now, very interesting development in this case was in Ratiram versus Union of India, while considering Section 309 IPC old provision, which criminalized attempt to commit suicide. And this is the only provision in the law where attempt is punished, not the complete act. The Supreme Court held that Article 21, which protects life with dignity, indirectly includes the right to die. And as such, attempting suicide is not a crime, but rather a call for help, and punishment such person is unjust. However, in the later case of Gyan Kaur, the Supreme Court reconsiders the judgment, and constitutional validity of Section 309 along with Section 306 IPC, old IPC, was considered, and this judgment was overruled, and again saying that suicide being an unnatural termination of life is inconsistent with concept of life, and hence it should be punished. In the very famous case, Aruna Shanbag versus Guardian of India, the fundamental right to die, was extensively considered. Possibly everybody knows this case. Aruna Shanbag, a young nurse, was strangulated by her co-worker, and she was in coma for decades. And then when there was no chance of her coming back, some of the NGOs filed a case before the Supreme Court to terminate her life by disconnecting to the life-saving machinery. But Supreme Court in that case did not allow it. But there, first time, principles about the passive euthanasia was considered. Now by this, and the next cases are Parmanand Katra, Paschim Bang Khet Mazdoor Samiti, and Parvat Kumar Mukherjee. There it was again emphasized that right to die is also permissible provided there are certain conditions are fulfilled, especially only in the cases of the terminally ill patients who can't at any cost come back to the normal life. In Murli Deora's case, considering the harmful effect of passive smoking in public places, it was held that right to life under Article 21 was infringed upon by exposure to tobacco smoke, and as such, order for banning the smoke. Now, of course, most famous judgment latest was K. A. Putswamy versus India, Union of India. Justice he was a judge from Karnataka High Court who, after retirement, filed this litigation case. And there it was held that right to privacy is not explicitly stated in the Constitution, but has been progressively recognized as fundamental right under Article 21. The court recognized the privacy as intrinsic to the right to life and liberty and emphasized its foundation role in ensuring human dignity. Friends, these are very few selected judgments to show how the Supreme Court has defined and redefined and expanded the object and scope of right to life, and especially the meaning to the word life under Article 21. Thus, Article 21 has been the cornerstone of fundamental rights in India, evolving thorough progressive judicial interpretations. It ensures that life is not merely about survival, but also encompasses dignity, liberty, and fulfillment. I remember Nelson Mandela once said, to deny people of the human rights is to challenge their very humanity. And this is exactly what the Honorable Supreme Court has been saying through its various judgments while interpreting and expanding the meaning of the Article 21. Most of us are enjoying enviable quality of life in India today. It is due to the relentless and unparalleled innovations by the Supreme Court in various judgments. George Washington once said, liberty, when it begins to take root, is a plant of rapid growth. This is what exactly we are seeing today by the interpretation of various judgments of the Supreme Court. I conclude with my pranams to the great visionaries who crafted the Constitution of India, and especially Article 21, and all to the all great judges who interpreted and protecting our right to life. Thank you very much.
Now I request Professor Vijay Kumar may take 12 to 13 minutes, not 12 plus 13. One more minute, grace minute.
Yeah, then I'll reduce my address to the extent that is possible. The panelists present on the dais, my learned colleagues, and my dear students present here. A good afternoon to everyone present, and then it's a pleasure always to come back to NLIU Bhopal. As Justice Banurmat has very clearly enunciated the way the Supreme Court has gone around over a period of time, I quickly present three different stages. The first one being the evolution of right to life, both national and international, without which the jurisprudential basis possibly may not be available to us. The second phase between 1950 and 1978, which I call it as a period of self-restraint. In the morning session, there was a discussion on judicial activism, but I consider this period, 1950 to 78, as a period of self-restraint, barring few exceptional, decisions given by the court here and there. But 1978 onwards, the period of judicial activism.
Madam Professor Manav Purohit also has enlightened. And here I would like to add one or two things which are not touched. Because Professor Vijay Kumar has went beyond India. He touched Magna Carta and also he touched John Locke. Yes, the British philosopher who in the initial days of colonizing United States of America, it is he who has propounded the three inalienable rights, that is life, liberty, and property. Because the colonial masters, what they did was, whatever the land that they have occupied, they want to control the land, they want to take the ownership of the land. That's the reason why they added property also as inalienable rights, because John Locke was the first philosopher who has propounded these property rights. And I said that the three alienable rights, the first right is right to life, second is liberty, and third is property. And even if you see the American Constitution, they made a little change of John Locke's principles. They made it in their preamble in the Constitution. It is life, liberty, and pursuit of happiness. My Constitution Professor Madhu is here. So, since then, we have adopted, and Justice Banurmat has very elaboratively has explained how Bengal Narsingh Rao and how this right to life has been incorporated. And in the initial days, this right to life has been revolved around the criminals, police torture, violence, custodial deaths, and the conditions in the prison, inhuman conditions in the prisons, etc., etc. That is mostly the periphery of the criminal law. And later in the second generation has come environment, that is clean environment, and then right to pavement dwellers, and all these rights has come up. That one right that has been ignored, that is, if you look into, this is also further expansion of the right to life. As Justice Banurmat has referred to Bandhuva Mukti Morcha. So in Bandhuva Mukti Morcha, for the first time, the directive principles were read into fundamental rights. That is, as we know that Part 3 deals with fundamental rights, Part 3 of the Constitution speaks about the fundamental rights, and Part 4 of the Constitution speaks about the directive principles of state policy, which shall be fundamental in the governance of the country. That is, in fact, directive principles of state policy is the people's manifesto. That is how a political party should run the state. Okay, coming back to, under Article 21, that is right to life. As right to life, life has different dimensions. And courts, they pursued every dimension of life and incorporated. And then coming back to the directive principles, where there is equal pay for equal work, the minimum wages, the living wages, and human conditions of work, safety of workers, and maternity leave, and all these welfare provisions and security provisions for the workers' welfare. All these things, for implementation of these directive principles of state policy, there are certain laws were made, and certain laws, there are no laws. And then Supreme Court considered that, Supreme Court read all these directive principles into fundamental rights. That is, equal pay for equal work, interstate migrant laborers, the maternity benefit to women workers, and all these things, and including the wages, bonus, and all these things, they were read into Article 21, that is the right to life. So here my submission is that Article 43, it speaks about the living wages, that the Indian working class, whether it is agriculture or industrial or everyone who is come under the working class, they shall be paid living wages. Living wages means that wages in the wage structure, because work is an economic necessity and everyone works in order to survive or living. What is the difference between survival and living? Siddharth? Animals survive, and in a civilized society, human beings should live. So, whether it is Asiad workers case, that is People's Union for Democratic Rights versus Union of India, Bandhuva Mukti Morcha, or Salal Hydro project, and many other cases. And it was Justice P.N. Bhagwati, and before P.N. Bhagwati, Justice V.R. Krishnayar said that even in common cause, they have stated that right to life doesn't mean mere animal existence. It is dignified life in a civilized society. So when a human being will live in a civilized society with dignity and with all amenities, that is only when he is paid the living wage. So, as work is an economic necessity, as I said, that everyone works for a good, decent living. So the rock bottom wages is the living wages, then fair wages, and then the highest wage that is paid in the developed nations, it is the living wage. And the Constitution, the directive principles of state policy, envisages that every worker, every employee in India should get the living wage, which ensures, which guarantees a decent standard of living. And I hope that still now, the Supreme Court and even the high courts, they are only looking, and even there is a lot of resistance even from the employers. We are struck with the payment of minimum wages. We only have the Minimum Wages Act. We do not have the fair wages. We do not have the living wages. And I hope that in future, the high courts and the Supreme Court, when they expand, when they look at the right to life, they may give the interpretation in such a way that right to life may include the living wages, not the minimum wages. So, as different dimensions of right to life has been discussed, if anything is left, Siddharth also has come with very good preparation, but you won't get much time, only 12 plus 1, 13 minutes. Thank you very much. Thank you for your patient listening. Now Siddharth, 12 plus 1, and you will take another 2, mujhe pata hai, already this is.
Please, okay. I request the dignitaries on the dais to please don't count my 2 minutes of the beginning, because I'm the last speaker and I can see that 9-10 students are sleeping at the back, so I need to wake them up. I need to wake them up, so 2 minutes would be spent. Honorable Mr. Justice S.R. Bhanulmat, former Chief Justice, Kerala High Court, respected Professor Surya Prakash sir, respected Professor Vijay Kumar, former Vice Chancellor, NLIU, respected Professor Madam Mona Purohit, Dean, HOD, Barkatullah University. So I would like, this is out of the course of my speech. I would like to start with a humor, and this was narrated by none else but by Professor Surya Prakash himself. I was reminded just now, 23 years back, he used to teach us constitutional law. So, despite the subject being very interesting, the timetable at that point of time, this was my sixth trimester, there was a trimester system. And the constitutional law class used to start at 12 o'clock and used to continue till 1:30. So by that time, all the students used to get their energies drained, the attention had disappeared, and half of the class was. So you used to enter the class and start with a courtroom humor, which used to wake up all the students in one shot. And that's what I'll be doing. I'll be repeating one of the courtroom humors you told me. And I was able, and I did Google also to check whether I'm right on facts or not after 23 years. There was pre-independence. Bombay High Court was a chartered high court. There was a very strict judge. His name was Matthews Richard Sauce. He was considered to be very austere and strict. And his peculiar problem was that after lunch, his temperament used to rise further. So there was a senior advocate. It was around 3:50 p.m. post-lunch. And he was not interested in going in the court. And he wanted to avoid that court because, after all, his case would have suffered. So he asked, I'll name that junior counsel a little later. He asked the junior counsel, look, gentlemen, please handle this time. You do something and see that the matter is not heard. Go and appear and do something. The junior got panicked. As it is, was the most strict court, the strictest of court at that point of time. So he said, sir, I'm not prepared what to do. You go and handle, that's your wit now. That's how you'll develop in the bar. So he goes there and politely, so this gentleman, Matthews Richard Sauce, who had his tempers running high by 4 p.m., he said, yes, counsel, what do you want to say? So he says, sir, what is the time? He says, what? Sir, you please repeat, what do you want to say? Sir, what is the time? So judge actually hit the roof. He said, which office you are from? I represent so-and-so senior. He asked the court sheriff, the court master, call his senior. He has sent this mannerless junior in my court. Call his. Now by that time, the senior was in the parking lot, boarded his car to leave the High Court peacefully. Bombay High Court. So the court sheriff went, pulled him out of the car he was sitting in, and said, Sir, Judge Saab bula rahe hain, aapko jaldi chaliye, your junior has done a blunder. So the senior went rushing to the court, and as it is, he had already surrendered. Said, sir, my lords, your junior, you have not taught him the decorum of the court, he's asking me time. What is the time? Can't he see the clock? So the senior asked his junior in the court, what are you doing, gentlemen? I asked you for it to get the adjournment. Sir, the junior politely replied, sir, that is what I was doing. I was asking for time. So please don't count this time, because my effort was to wake the audience up. So my today's topic is, I presume everybody is in sync now. My today's topic is right to digital life and informational privacy as facets of Article 21. Lord Edward Coke, former Chief Justice, wrote in the year 1604, a man's home is his castle and fortress, as well as his defense against injury and violence as for his repose. This was developed further by James Otis Jr., a noted American lawyer, who said, a man's breeches and the sovereignty beneath his hat cannot be disturbed even by the king. In the 15-minute slots I have, I'll just deal with 3 parts. Part 1, I'll deal with the overall concept of informational privacy. Part 2, international and national perspectives on privacy, especially data protection as a facet of Article 20, as a facet of life and liberty of an individual, Article 21 in the Indian context, and how it has evolved. And then the Indian context. And part 3, I'll speak about the right to digital life under Article 21 and the concomitant rights flowing out of it, which are prospective, not yet evolved now. Now, what is informational privacy? It's a buzzword in the digital world today. Informational privacy can be explained as an individual's absolute right to control the terms under which his personal information identifiable to his identity, personality, and lifestyle is controlled by him. The spirit of which lies in controlling disclosures or third-party access to his individualized know-how. A question might arise, what is the personal information? What is the indicia to determine personal information for claiming Article 21 or right to life and liberty? In 1995, the US Department of Commerce did a study, and after doing study, it tried to define the personal information, what it encompasses. Information, it broadly defined it as information that bears an ownership relationship with the individual, A. B, information that is descriptive of the individual, and C, which has instrumental mapping with the individual, his unique features like the biometrics, his blood group, his gene combination, his sex, his fingerprint, etc. So that takes me to the privacy in the international context. In the United States, right to privacy came to be first identified as part of the Fourth Amendment to the US Constitution in 1967 in the judgment of Katz versus US. This was developed further in the controversial judgment, you must be aware, of Roe versus Wade involving the abortion rights. It was mentioned by Mona Purohit madam briefly, wherein it was held by the court that an individual enjoys personal privacy in most of his intimate affairs. Recently in 2019, in the case of Carpenter versus US, the Supreme Court extended the ambit of this right to hold that no person's mobile location or Google location can be tracked by any third party without a warrant procured or issued by the competent court on an application moved by the government. Clearly, this is a new dimension to the right to informational privacy. Now, coming to Europe, the European Union. In fact, European Union is the only continent in the world where the personal right to data protection has assumed the form of a written code or a written form by way of what is known as EU General Data Protection Rights, which provides a series of rights, the breaches of which invite severe civil and criminal remedies. In fact, Europe has awakened to the privacy rights of its citizens way ahead of the other countries of the world. And in fact, in the recent past, I would like to quote certain examples. In the recent past, penalties staggering to huge amounts have been imposed on tech giants for invading the privacy of its citizens. I like to give certain examples. In December 24, Italy's data protection agency, Garant, fined OpenAI 15 million euros when the company used personal data to train ChatGPT without informing consumers. December 24 only, Netherlands fined Netflix 4.75 million euros for not giving its customers enough information about what is being done with their personal data. May 23, Ireland imposed Meta, known as Facebook, $1.3 billion for violating Article 46(1) of GDPR for transferring without the express consent of the data owners the data from European Economic Union to the authorities in the United States. So on and so forth. Now, that takes me to the Indian context. Indian context, right to privacy. There has been a lot of literature, all of you, I presume, must have read. Essentially, there are two ends of the spectrum, where on one hand is the 1954 judgment of MP Sharma versus Satish Chandra, which was overruled in 2017 by a 9-judge bench of K.S. Puttaswamy. So I'll not touch too much on that. Just to mention the few milestones or the stopovers in between. In Govind Singh case, which was the first case discussing privacy threadbare, Justice K.K. Matthews said, individuals need a place of sanctuary where they can be free from societal control. The importance of such a sanctuary is that individuals can drop the mask, desist for a while from projecting on the world the image they want to be accepted themselves, an image that may reflect the values of their peers rather than the realities of their natures. Then we have judgment of R. Rajagopal, District Registrar Canara Bank, X versus Hospital Z, all developing the privacy jurisprudence. But K.S. Puttaswamy was the judgment which actually read in privacy as the content of Article 21. Now, in 2019, an interesting judgment came which further expanded the boundaries of right to privacy. This was Indian Hotels and Restaurant Association versus State of Maharashtra. There was an interesting issue before this court in this case. In a bid to control illicit human trafficking, the state government enacted certain provisions, and by virtue of which there was a CCTV surveillance on the stage performances of all the women bar dancers. This data was archived, stored, and could be accessed by the state agencies whenever they wanted to. So the question arose whether this amounts to entrenchment on the informational privacy of the women bar dancers. The Supreme Court, going a step beyond K.S. Puttaswamy, held that informational privacy demands that CCTV surveillance should not be constant or data should not be shared unless and until it is firstly duly authorized by a senior officer of the state, and only that data that is required for inquiry into any aspect. The provisions were struck down as excessive and disproportionate. So that was the jurisprudential development through judicial judgments. A watershed development insofar as privacy is concerned took place in August 2023 when the Parliament enacted the Digital Personal Data Protection Act. Why I call this watershed? Because for the first time, privacy, informational privacy and data protection have been protected statutorily by the Parliament of our country. It has 9 chapters with a schedule appended to it, wherein the civil liability can go to the extent of rupees 250 crores on any entity, tech giant, violating privacy rights. I'd just like to mention few salient features of this act because time is running short and I cannot refer to the provisions threadbare. There is a provision of express written informed consent of the data owner, which is known as the data principle in the enactment, without whose the data cannot be procured by the data fiduciary and it cannot be shared with a third party. If the sharing happens, then it is punishable under the Act with both civil and criminal consequences. Also, after sharing of the data, the consent is not treated as absolute. The consent can be withdrawn completely or partially, which means that if certain data is to be withdrawn by the owner or redacted by the owner, that is permissible. Or if partial data is to be done, that can also be done under the enactment. And lastly, an ombudsman, a strong regulatory body, titled as Data Protection Board, has been enacted under this Act of 2003, which has been vested with the powers to deal with complaints of privacy violations. That takes me to the last part of my speech, right to digital life under Article 21. We have heard of right to life, but what is right to digital life? A new concept. It takes within its sweep a broader discussion about the new rights evolving with the passing of every day. Rights which we may not be conscious of today, but they are intricate to our exposure to digital devices, which we are nowadays 24/7. iPads, mobiles, MacBooks, LED. So throughout 24 hours, we are surrounded by digital devices. Before I go on to expand what the summary of these rights, which I project in next 6-7 years, would be developed by the courts across the globe, like to give 2 examples, and you'll find them interesting. A few weeks back, I was sitting with one of my clients who is into real estate investment. So we were just discussing, this is in the noon hours, we were just discussing that where is the corporate investment going on in India these days. So he was telling me that it is going in Oman, UAE, Dubai, everywhere the corporate investment. So I joked with him, that's not my cup of tea. Better you give these ideas to some senior counsel who can make these investments in Dubai and all. And the conversation ended there. I retired for the day. In the evening, when I logged into Facebook, some 2-3 editorials started popping randomly about Danube properties in Dubai. I was wondering, how is this coming and how is this relevant to me? Then I recalled that this phone which was being kept aside me was overhearing me. And the AI-driven targeted advertising and predictive analysis, what is being called, it was hearing me, the AI engine had started working, and it was giving me advertisements of Danube investments in Dubai. Danube is basically a real estate company which is providing investments for middle and upper middle class, Indians also. So this is what happens, that your devices, your digits are hearing you constantly. The other example is, this is again last month. After day-long incessant working hours, which is common in litigation, with a bad throat, bad cough, I went off to sleep around 2 a.m. in the midnight. I was coughing, feeling restless throughout the night. When I got up and just checked in and logged in my Insta account, I could see that certain random advertisements about cough syrups and tablets were coming. I could not understand why this is being offered when I have not asked Insta about it. Because the net was on and Insta heard me coughing. If not my wife, my kids, Insta was concerned about me. So this is what technology today is tracing you even when you are asleep, fast asleep. And now, with this context, with this prelude, I would like to give certain rights which have to be read in under Article 21. The first is the right to be forgotten, wholly or partially. What is this right to be forgotten? Somebody would like to be remembered, not forgotten at least. Right to be forgotten is that an information which is available on Google or internet platforms about me, which I feel is not relevant to my life today, to my reputation, standing today, I have a right to get it redacted from the Google or online platforms. The Delhi High Court has passed certain verdicts of lately, holding that right to be forgotten involves a direction to be issued for deletion of the data from Google. The associated with this right to be forgotten is right not to be known. Now, what is this right not to be known? The right not to be known is, and it has been recently recognized also in European Union by virtue of GDPR, General Data Protection Regulations, which I mentioned a few minutes back, wherein if I do not want to know something or I am not interested in something, the mobile or the third-party apps installed in it, Twitter, Insta, Facebook, whatever we are in, or Threads now, Insta Threads now is the new, should not offer me that information which I am not inclined or interested in. I see whenever I log in my mobile, there are apps which are asking me or showing me that you are aging very fast. Your muscles are aging. Do you need a solution? How to handle the status of your mental well-being or cerebral equilibrium. Even if there is not a worry, they create a worry. So I am a peak Virgo. So somewhere I must have shared my date of birth. So a horoscope prediction came up one day, which was predicting what my life would be after 5 years. So basically, Google is predicting more what my astrologer can do actually. This is what is right not to be known, what you're not interested in. The next is right to be offline. This has also been recently, one of the federal courts in US has directed the Meta, Facebook, to frame a policy on right to be offline. Now what is right to be offline? One can say that I can switch the data button off and I'll be offline, or I can put the mobile on the flight mode and I'll be offline, but that's not the end of the matter. We are being chased constantly by all these apps by virtue of the fact that they are on our mobile. And like I said, Google is as deep as Pacific Ocean and deeper than Mariana Trench. So the right to offline encompasses the right to be let alone from all these third-party apps, the constant monitoring or surveillance of our day-to-day activities, movements in the society or anywhere. It is, in other words, it is also known as going off the grid. The last is the right not to be discriminated again, or right to equality in the online platforms. Again, something new. Now, what is this right not to be discriminated against? I'll give another example. Recently, Ministry of Corporate Affairs, Government of India, has instituted a probe against Ola, Uber platforms. There were allegations that for users using Apple devices, they were charged higher for the very same rides, which were charged lesser for their Android counterparts. And there is a complaint against various food delivery companies also, online companies, food delivery platforms, of charging higher when order is placed from an upscale location of the city compared to an order placed from a downside location. And this problem is becoming frequent. So the question arises is whether I can claim equality or non-discrimination on online platforms. So these are the rights, like I said, to evolve in the next 6-7 years. The discussion was just to compel you to indulge into a brainstorming and mind-churning exercise. Someday or the other, all these will also be acknowledged as formal rights. With this, I would like to express my gratitude to the audience, especially the students whom I woke up from deep slumber. And I am thankful to the members of the Student Bar Association. Excellent coordination, excellent arrangements. May the next year be much grander, much bigger, and I wish you success in all your endeavors. Thank you. Thank you, Professor U.S. Surya Prakash sir.
Thank you, Siddharth. I know that you have come prepared very well. I will invite you to give an extension lecture, and I will ask our Professor Atul Pandey. We are planning to conduct one program on digital rights and privacy. We will invite you. There you will get full time. Okay? Thank you. The session is completed.
With this, we formally come to the end of the session on the Supreme Court and the evolving dimensions of the right to life. It was truly an insightful and entertaining session, and I'm sure the audience is left with a lot of food for thought. I request the audience members to remain kindly seated, as we will be beginning with the valedictory within the next few minutes. Thank you.
Hello. Greetings, ladies and gentlemen. Bhagavad Gita, chapter 4, verse 7. Yada yada hi dharmasya glanir bhavati bharata abhyutthanam adharmasya tadatmanam shrijamyam. When righteousness wanes and unrighteousness prevails, O Bharat, I manifest myself to restore the balance. This timeless verse from the Bhagavad Gita reminds us that every end, no matter how overwhelming or final it may seem, carries with it the seed of a new beginning. Often the close of one chapter marks the quiet dawn of a deeper, more conscious journey. On that note and in that spirit, ladies and gentlemen, May the end of this conclave not be a farewell, but the beginning of a renewed engagement, one where we read the law with a different lens, not just to interpret it, but to internalize, critique, and connect with it more meaningfully. A very good afternoon to our esteemed guests, respected faculty members and students present here. I, Prachi Chaudhary, along with Ms. Vaishnavi Salamat, are here to welcome you all to the valedictory ceremony of the first edition of NLIU SBA Law Conclave. Ladies and gentlemen, a huge round of applause for the conclave we've had so far. And may this be the spark for the renaissance within each of us. Today it is our privilege to host an extraordinary panel of guests. I extend a heartfelt welcome to Honorable Justice S.R. Banurmat, former Chief Justice of High Court of Kerala, as our chief guest. So could you please join us on stage? Ladies and gentlemen, next up we have Mr. Radhela, Dr. A. Lakshminath, Distinguished Professor Emeritus and Professor NLIU Aurangabad as our distinguished guest. Professor Dr. R. Venkatrao, Vice Chancellor, IUILER, as our distinguished guest. And now I welcome our very own Professor Dr. S. Suryaprakash, Vice Chancellor, NLIU Bhopal, and Professor Dr. Raka Arya, Dean Student Welfare, NLIU Bhopal. Ladies and gentlemen, let us take a moment to express our heartfelt gratitude with a warm round of applause to this esteemed panel. We are truly honored by their presence, given so that they have such demanding schedules and commitments. To the panel, we see each one of you, and we are immensely grateful for your time, support, and efforts. Now, as we come to the close of this incredible journey together, it feels only fitting to pause and reflect and acknowledge a moment of national significance. I am talking about the 75 years of the Supreme Court standing tall as a guardian of our Constitution, protector of our rights, and a guiding force in our democracy. To mark this remarkable milestone, the Student Bar Association of NLIU had the honor of hosting the very first edition of NLIU SBA Law Conclave. Ladies and gentlemen, the past 2 days were not merely an event. It was a celebration of the Supreme Court's enduring legacy and its pivotal role in shaping Indian jurisprudence. Through the course of this conclave, we had the privilege of hearing from finest of minds, jurists, scholars, and students. And at this juncture, I must confess, witnessing the panel discussions during this conclave has been truly and deeply transformative. The conversations were not easy, they were not comfortable, and they were not meant to be. It was, in the best possible way, challenging me to confront my own positionalities. It revealed to me that in the field of law, there's always a lot more than what meets the eye. It revealed to me why platforms like this matter. So we are proud that this conclave could become a part of that dialogue, and as students of law, it serves as a powerful reminder of the responsibility and promise that lie ahead of us. Now, as a token of our gratitude, we are honored to present our esteemed dignitaries with bouquets. As a symbol of our heartfelt appreciation and respect, their presence have truly made this occasion very special. I kindly request Professor Dr. S. Suryaprakash to present the bouquet to Honorable Justice Shri S.R. Banurmat. I kindly request Sir to present the bouquet to Honorable Justice Shri Dinesh Kumar Singh. Next up, we have Mr. Radhilal Gupta. I would request Sir to kindly felicitate Professor A. Lakshminath. Next, I would request Sir to kindly present the bouquet to Professor Dr. R. Venkatrao. And finally, I request Sir to kindly felicitate Professor Dr. Rakarya. नहीं, sir. Sir, आपको करेंगे.
ठीक है, because you are the person behind the entire event. Don't worry.
I now request Mr. Yashpal Jakar, President of NLIU Student Bar Association, to kindly felicitate Professor Dr. S. Suryaprakash, sir. Next, I would like to request Honorable Justice Shri S.R. Banarmat to please join us and kindly present a token that carries both meaning and memory. To the distinguished guests who graciously encouraged and accompanied their students to participate in this conclave, we present to them a miniature statue of Raja Bhoj, symbolizing the clarity of thought and the depth of knowledge he stood for. I would request Ms. Prashasti Patni, Assistant Professor, Sage University, to kindly join us on the stage. I would request Dr. Tai, Dean Faculty of Law, Mansarovar University, to kindly be on stage to receive the token. And lastly, I would request Professor Dr. Anushka Nayak, Head of Department, LNCT University, to kindly be there on stage. Thank you, sir. Thank you so much. It is now my honor to welcome our esteemed Vice Chancellor, Professor Dr. S. Suryaprakash. Sir has been serving as the Vice Chancellor for NLIU and has also previously served as the Vice Chancellor for MNLU Aurangabad and DSNLU Vishakhapatnam. With an illustrious career spanning across 25 years in academia, Sir is also an expert in jurisprudence. And with all humility, I would like to call Sir on stage. Thank you so much, sir. I invite you to be here to share your kind thoughts and words of wisdom.
Good evening to all. I welcome Honorable Justice Banurmat, Chief Guest for this today's program, Honorable Justice D.K. Singh, Judge, High Court of Kerala, for gracing today's valedictory program, Shri Radhalal Gupta ji, Chairman, MP, State Bar Association, Professor A. Lakshmanath, my teacher from Andhra University, former Chancellor, and Professor Lakshmanath is the only Professor of Law who was Chancellor and also Vice Chancellor of two national law universities. And he is the senior most Professor of Law in India as in today. And my another teacher, Professor R. Venkatrao, former Vice Chancellor, NLSIU, Bangalore, presently working as Vice Chancellor of International Law University, started by the Bar Council of India at Goa. And my colleague, Professor Rakarya, my registrar, Vivek Bakshi ji kahan hai? So the man who guiding the students for the last 1 month, and my controller of examinations, Mr. Baguna, and my learned colleagues, professors coming from different universities, my predecessor, Professor V. Vijay Kumar, students and faculty members coming from other law colleges and other universities, and above all, I should congratulate the SBA President, Yashpal Jakar, Dhankar ji to Vice President ho gaya, and he conceptualized, he came to me, sir, we should conduct a grand event, and he conceptualized this law conclave, bar, bench, and beyond. And my dear student friends, as we are already running late, I do not want to take much time, but because the title, Law Conclave, Bar and Bench, I would like to give you 2 instances regarding bar and bench. So the first one, as we know, we inherited a wonderful judicial system. I am not praising the Britishers and colonial masters, but even a devil deserves its due. One good thing that we inherited from the British is a very good judicial system with discipline, commitment, and efficiency of par excellence. Our judges, they're second to none, before independence and after independence. And we always celebrate one of the greatest judges for integrity, that is H.R. Khanna. And now I would like to tell you about one more, a great judge. Though he was not a judge of the Supreme Court or the Federal Court, it was, I would like to narrate an incident that happened in the Calcutta High Court before independence. There was one judge, Justice R.C. Mittal, and he was the youngest judge. This happened sometime of the Calcutta High Court. And before independence, the 3 great high courts, that is Bombay, Madras, and Kolkata, and he was serving as judge of the Calcutta High Court. And in the High Court and in the court, the senior advocates, wakils, they used to get preference. One day, the juniors, they appealed to him, "My Lord, we are unable to get your time. Please give us time to present our matters," something like that. So, Justice Mittal, he has given time. Probably that was Saturday or Friday. He said that, okay, next Monday, next day I will give you the preference, and you please come at 10 o'clock, 1 hour before the scheduled timings. So 1 hour I will give you time, and after that I will go for the regular proceedings. But Justice Mittal, he came on the bench as usually at 11 o'clock. And all the juniors to whom he has given the time, they came at 10 o'clock and they were waiting for the Honorable Justice. And Justice has forgotten, and he came as usually at his regular time. And when he saw the juniors in the court hall, then he realized that he has given the time, but that has slipped from his mind. He felt sorry, and this is only one instance in the world. Nowhere it has happened. The same day evening, he put up his papers saying that a person with failed memory is not fit to be a judge of the High Court. And the Chief Justice Rankins, the British judge, he requested, and other judges also, this is a small, trivial matter, don't worry. You can give them time. Today or tomorrow, you can give any number of hours to the juniors. But Justice Mittal, he didn't reconsider his decision. He stuck to his decision, and he submitted his papers on the same day, and he walked away from the Calcutta High Court. This is an instance of unparalleled. Whether it is right or wrong, I am not judging. This is only an incident. And if you want, there is one book on Indian judiciary written by Panna Laldhar. He has referred this incident, and there is no such parallel in any court anywhere in the world. That was the highest form of integrity, discipline, maintenance of timings of the Indian judiciary. So my friends, this is one story. As for when the tagline of this law conclave is bar, bench, and beyond. And now I would like to, this is regarding the bench, I would like to give one more instance regarding the bar and how sharp an advocate should be. So you know that in 1985-86, there was a political turmoil in Andhra Pradesh, and Mr. N.T. Rama Rao, the chief minister, he was dethroned by Chandrababu Naidu, and both maintained their camps, and both maintained that we have the majority. And finally, N.T. Rama Rao and the then governor invited Chandrababu Naidu for swearing ceremony, and N.T. Rama Rao, he challenged the decision of the governor. And it's only the subject to satisfaction of the governor. If he feels that so-and-so party has the majority, he can invite. And if I remember, Kapil Sibal and Manu Singhvi and all the top lawyers from the Supreme Court bar were drawn to Hyderabad. And just I would like to, last 5 minutes of the arguments. And Justice P.S. Mishra and the two judges, they have been asking, is there any precedent that the governor should call only the majority of the party only when he has shown or he has the majority that to be proven. Majority always has to be proven on the floor of the house. So there is no need for parading the MLAs in the governor's house or Raj Bhavan. And the bench has been insisting, and the defense counsel was Kapil Sibal. So what is the precedent? Do you have any precedent that the governor went wrong, etc., etc.? And the last statement, before concluding the arguments by Kapil Sibal, he said, that is quoting the relevant provisions, "Milord, if you are wrong and I am wrong, you are correct and I am wrong, that is the constitutional position." I think you got it. If you are wrong and I am wrong, you are correct, you are right, and I am wrong, this is the constitutional position, and N.T. Rama Rao lost the case. That's a different story. So the arguments, the hair-splitting arguments that took place. So I'm happy that the present SBA has took a great initiative, and this is only the beginning, and they set a precedent, a trend, and I hope that next SBAs also will continue this legacy of conducting SBA and reviewing through law conclaves, reviewing the judgments or any other topic. And I want to see all the guest students who has come from different law schools and my law school to come and to join and to participate. And I express my deep sense of gratitude to all the dignitaries on the dais for making this program a grand success. Thank you very much. Jai Hind.
Thank you so much for your words and anecdotes, sir. Today, we also have with us Mr. Radhilal Gupta. He is a distinguished legal professional with over 43 years of experience at the bar. Beginning his practice in 1978, he's trained under eminent legal minds including late Shri S.A. Avasthi and Honorable Justice Shri D.M. Dharmadhikari, former judge of the Supreme Court of India. Over the years, he has held several prestigious positions, including Assistant Solicitor General of India, Additional Standing Counsel for the Government of Chhattisgarh, and Special Prosecutor for the CBI. He has been elected 4 times to the State Bar Council of Madhya Pradesh, serving as key roles as Treasurer, Co-Chairman, Spokesperson, and members of other vital committees, tirelessly working for the welfare of legal fraternity. Mr. Gupta has handled numerous high-profile cases and with a rich practice in constitutional, service, civil, criminal, and revenue laws. Sir, I'll kindly request you to address the gathering.
Respected Honorable Justice S.R. Narjumat, former Chief Justice High Court of Kerala, Chief Guest of today's program, Justice Dinesh Kumar Singh, Judge High Court of Kerala, Professor Lakshminath Ji, Professor R. Venkata Rao, Professor Dr. S. Surya Prakash Ji, Professor Dr. Rekha Arya. Faculty members of NLIU and other law colleges, office bearers of Students Bar Association, its volunteers, and dear students present in the audience. A very good afternoon to all of you. Almost all the topics have been covered in the last 2 days in the informative conclave convened ably and successfully by the Student Bar Association. The first of its own conclave showcased expression of view ranging from judicial activism to fundamental rights under the Constitution of India, basic structure, doctrine and digital rights in the information age, how the Supreme Court has contributed to the evolution and development of law in the last 75 years has been discussed by several eminent professors, academicians, judges, and lawyers yesterday and today. Therefore, it was very difficult for me to discern the topic on which I should speak upon the valedictory on being extended the invitation for it. I was in dilemma about the topic to speak upon with the mention of Supreme Court in the last 75 years. Being a member of and chairman of State Bar Council, therefore I thought it appropriate to discuss the contribution of some notable lawyers in passing of various landmarks judgment by the Supreme Court in the last 75 years. We have heard and read quite much content upon the lives and contributions of eminent lawyers like Dr. B.R. Ambedkar, Mr. B.N. Rao, Mr. N.S. Nariman, and many such others. However, there have been many other senior advocates who had also worked equally, diligently and quickly, but their reference does not find a place so frequently in the annals of the legal history. I would mention the contribution of some of the legal luminaries whose contributions have been otherwise scantily discussed in the Indian legal literature. Sri Anil B. Diwan. Anil B. Diwan is one of those legal luminaries who has not been given the space and place in the legal history which he deserves. I must mention that his son and daughter-in-law are today eminent lawyers in the Supreme Court, which Mr. Syam Diwan and daughter-in-law Mrs. Madhvi Diwan. Mr. Anil Diwan was a distinguished Indian lawyer and constitutional expert who graduated from Government Law College, Bombay in the year 1950s. His distinguished brilliance has earned him gold medal for his academic excellence. As arguing counsel, he had contributed significantly. He was also one of the main advocates in the landmarks of the judgment of D.S. Nakra versus Union of India, wherein the Supreme Court held that arbitrary fixation of cut-off dates cannot be done, especially while fixing the pensionable amount to the retired government employees. Mr. Anil Diwan was also appointed as the amicus curiae in the landmark Vineet Narayan case, also popularly known as Jain Hawala case, in 1997. In Vineet Narayan, accepting Mr. Diwan's suggestion, the Supreme Court issued slew of directions pertaining to the independence of investigation agencies like CBI, Central Business Commission, and accordingly them statutory protection and insulating them from legislative and bureaucratic interference. Vineet Narayan was a landmark verdict which led to enactment to the Central Vigilance Commission Act and amendments to Delhi Special Police Establishment Act, making the CBI independent of governmental control. He was a man of ethics, principles, and throughout led a hermit's life. His legacy is characterized by relentless pursuit of justice, commitment to constitutional principle, and effort to ensure the independence and integrity of the Indian judicial system. K. Parasaran, the next eminent lawyer, also an eminent jurist, known as the Bhishma Pitamaya of the Indian bar, is K. Parasaran. K. Parasaran was born in a small village of Srirangam, Tamil Nadu, and he started his practice after graduating in the year 1949. He shifted his practice in the year 1958 to Supreme Court of India, whereafter graphs started rising northwards. Thereafter, he was no looking back to Sri Parasaran. The distinctive feat of Sri K. Parasaran in his depth knowledge of Hindi, Tamil, and Sanskrit literature. Mr. Parasaran has been instrumental in several landmark cases that have had a profound impact on India's legal landscape. One of them being the Ayodhya land dispute case, where he represented Lord Ram Lala in Supreme Court, advocating for the construction of the Ram temple in Ayodhya. It is because of his deep understanding of the Hindu scriptures and literatures he was able to persuade the court to pass a decree favoring the Ram temple's construction. The next is the case of S.R. Bombay versus Union of India, where Mr. Parasaran challenged the misuse of President's rule under Article 356 of the Constitution of India, involving the misuse of President's rule in the states, highlighting the necessity of safeguarding federalism system in the country. He was also the lead counsel for the state Tamil Nadu, defending the reforms made by the state in the landmark verdict of Keswanand Bharti. Next is P.P. Rao, the other constitutional giant who has also been less discussed is Mr. P.P. Rao. Not only Mr. P.P. Rao was a senior advocate, but was also a distinguished Indian jurist in the Supreme Court of India, who was known for his flair and expertise in the constitutional law. After graduating from Andhra University, Nellore, he initially spent his time in academics and teaching university. It was after spending some time as an academician, which was the principal reason for his rise in the legal practice, he enrolled himself as an advocate in the year 1967. He was the opposite counsel defending President's rule in the BJP-ruled states post-Babri Masjid demolition in the landmark judgments of S.R. Bombay versus Union of India. He also opposed the levy capitation fees by private educational institutions on students for imparting education to them. His submission persuaded the Supreme Court to pass the landmark judgment restraining the colleges from realizing capitation fees from their students. The judgment is known as J.P. Unnikrishnan versus the State of Andhra, delivered in the year 1993. He was also counsel for P.V. Narasimha Rao in the MP's bribery case, wherein he assisted the Supreme Court in interpreting Article 94 and 105 of Constitution of India. His other landmark contribution as a lawyer to the evolution of constitutional jurisprudence are endless, but notable judgments include the judgment of 2002 by the Constitutional Bench in the matter of TMA Pai Foundation versus State of Karnataka, P.A. Imamdar versus State of Maharashtra, and the notable judgment of Best Bakery case arising out of Gujarat rights relating to power of NHRC. Because time is less, therefore I would conclude with the mention of these few names as of today. Every person who contributes to the development of constitutional law in any manner deserve a special place in history, and I felt that it was my duty to have mentioned a few names. I must congratulate and compliment the Students' Bar Association for organizing this conclave so successfully. I believe all the students constituting the Student Bar Association would also make their name in future amongst the legal stalwarts of the country. Thank you.
Thank you so much, sir. Now it's my true honor to welcome Honorable Justice Shri Dinesh Kumar Singh, currently serving as the Judge of the Kerala High Court and formerly of the Allahabad High Court. With an illustrious judicial career spanning over 36 years, Justice Shri Singh has had several key positions, including Administrative Judge of District Chitrakoot, member of various high-level committees related to judicial reforms, and chair of selection panels for both judicial and consumer forums. His deep commitment to constitutional values and legal clarity continues to inspire the legal community. Sir, we are truly privileged to have you with us today, and I please invite you to kindly address the gathering.
Justice R. Bhanumat, the former Chief Justice of Kerala High Court, Professor A. Lakshminathan, former Vice Chancellor of CLNU Patna, and so many farmers are prefix against him, so I will not say so many farmers. But he's an eminent professor. Professor R. Venkat Rao, Professor S. Surya Prakash, this is my second interaction with him. Once I was online with him. Sri Radhilal Gupta, the senior advocate and the chairman of the Bar Council, Madhya Pradesh. Professor Radha Arya, DSW, Dean of Student Welfare. Other distinguished faculty, the students who are the future advocates, jurists, judges, corporate leaders. It's too late in the day. I am sure most of you are tired. I will not take much of your time. I have not prepared any written speech to be very long. But today is a very special day. This is the day of Vaisakhi. Can anyone tell me that what is Vaisakhi without Googling it? Why it is celebrated? Neither Jallianwala. That's one aspect. This is a harvesting season, beginning of the harvest season in Punjab, which signifies equality, the respect to your work, merit, hard work. And second important thing is very, very important, which people don't know. 1699, today 10th Sikh Guru, Guru Gobind Singh, gathered his followers and they lay down the principles to be followed by Khalsa Panth, Panch Pyare, and other principles to be followed to fight against the injustices of the rulers who came here. This is a very, very important part on this day, when we are concluding. As the student who was comparing said, it is not end, it is a beginning to prepare for the next conclave. I must congratulate the student union of this institution for organizing such a wonderful conclave, inviting me. I don't know whether I deserve to be here or not, because as a galaxy of the eminent professors, eminent speakers who I heard in 2 sessions. But I must, the way you have conducted, the way you have organized, the way you have hosted, it is remarkable. And I wish you all success in future. I hope you will invite me again. So, though when I came, I prepared a long speech, but I didn't go to my text speech either in the first session or the guest of honor. Guest of honor, you know what does it mean? It's only an honor without, without real honor. It's only guest, a 5-minute speaker. So I will not take much of your time. You have already tired 2 days. I have seen the topics, wonderful topics you designed, wonderful the discussions which has taken place. I hope you will come out with a souvenir and you will publish it and send me a copy also. So thank you very much for being patient, so attentive, listening, discussing. I hope this conclave will enlighten you more and encourage you to pursue higher goals in your life, to be successful, to be useful, to contribute to the growth of this country and constitutional journey, which we started 75 years when the Supreme Court first came into existence in 1950. First sitting took place after the Federal Court. So thank you all. Thank you so much for inviting me.
Thank you so much for your words, sir, and it's a privilege to have you with us today on this auspicious day of Baisakhi. Now, it's my true honor to welcome Honorable Justice Shri S.R. Bannurmat, a highly respected jurist whose contributions to the Indian legal system spans decades. After completing his law studies in Belgaum, he began his independent practice in 1979, focusing on criminal and constitutional laws. He regularly appeared before the Karnataka High Court as well as the Supreme Court, earning a reputation for sharp legal insight and unwavering commitment to justice. He served as the state public prosecutor for Karnataka before being elevated to the Karnataka High Court in 1997. In 2009, he was appointed as the Chief Justice of the Kerala High Court. Justice Bannurmat is not only known for his landmark judgments, but also for his work outside of the courtroom. As a founding member of the Bangalore Mediation Center and a strong voice for mental health rights, his influence extends far beyond traditional legal practice. His expertise has been recognized internationally as well, with invitations from US Justice Department to engage with leading institutions such as Stanford University as well as Microsoft. Sir, we are deeply privileged to have you with us today. May I now invite Honorable Justice Shri S.R. Bannurmat to kindly address the gathering. Can we please have a round of applause for him?
Honorable Justice Dinesh Kumar Singh ji, Professor Surya Prakash ji, Shri Radhelal Gupta, Bhishma Pita Professor Dr. Lakshmi Nath ji, Dr. Venkatrao, Professor Arya, all the faculty members, all the participants in this conclave, and my dear students. It was wonderful conclave. For the last 2 days I am attending, and I must congratulate Sri Yashpal and his entire team of SBA for organizing a wonderful conclave and which I call it as it was a wonderful feast for thoughts. बौद्धिक बहुत बहुत बड़ा दावत आप सबने हम सबको दिया है. So wonderful, keep it up. And I was surprised that this was the first conclave organized by SBA, and it was so beautifully arranged. Keep it up. And personally, my thanks to all the organizers and Professor Surya Prakash ji for giving excellent help and hospitality in this 2 days of my staying. Thank you. God bless you all.
Thank you so much, sir, and thank you for your support for being here. The Indian Law Review Journal, which is the first law journal of NLIU Bhopal under the guidance of our Vice Chancellor, Sir, Professor Dr. S. Surya Prakash, has been launched, featuring insightful articles on contemporary issues. The journal aims to foster scholarly discourse and provide a platform for legal scholars to share their research. We hope this journal will serve as a valuable resource to not only students and academicians, but also legal professionals. I now kindly request the dignitaries to officially present the journal to the audience. I also request Professor Dr. Venkat Rao to address the gathering.
I would say 3 cheers to SBA of NLIU for so wonderfully organizing this 2-day conclave. To pick up the gauntlet exactly where Honorable Justice from Kerala High Court had said, if today is Baisakhi, yesterday was Hanuman Jayanti, and tomorrow is the birthday of Baba Saheb of Ambedkar. What a timing to hold this one. And today is also celebrated as National Thomas Jefferson Day in the United States to commemorate the birthday of the 3rd President of the United States, Thomas Jefferson. And the constitutional values for which he stood, you know that. My special congratulations to the team for one main reason. As you know, the rule of law runs like a golden thread through the Constitution. And by organizing such events, you disseminate rule of law culture. And therefore, each one of us would become a foot soldier of the Constitution. I quote Sholi Sharabji on rule of law. It must be remembered that rule of law is not one-way traffic. It places restraints both on governments and individuals. If the underlying principles of rule of law to become a reality in governance, it must foster rule of law culture. And the only true foundation on which rule of law can rest is its willing acceptance by people until it becomes a part of their own lives. And this conclave will go a long way in disseminating that rule of law culture, and I congratulate the students for such wonderful initiative that you have taken. Only one more point I'd like to say as to how proud you should be of Supreme Court of India. My eyes were opened when I was in Washington to participate in a similar conclave. During the lunch break, an 84-year-old professor took me for a walk. And do you know what he said? We bow down before the Supreme Court of India, he said. The reason being, it is the Supreme Court of India which has given us the public trust doctrine in environmental law. And in the United States, we follow that. That's the esteem in which the Supreme Court is held in Washington. and we are now celebrating the 75th year of the Supreme Court of India. Let me just conclude by saying both the Constitution of India and the Supreme Court of India are 75 years young, because institutions can never become old, only we can become old. And hearty congratulations for celebrating the event on such an epoch-making scale. And my special thanks to you for making me a part of such momentous celebrations. May God bless you all. Thank you very much.
Sir, you've not only been a pioneer in the field of legal education, not only serving as the Vice Chancellor of IUILER Goa, but also the Vice Chancellor of NLSIU Bangalore. With your words, you have truly inspired the next generation of lawyers. Sir, moving on further, I kindly request Professor Dr. A. Lakshmina to bless the event.
What is there to talk now? Everything is over. Valediction, valediction. Esteemed Lord Chief Guest, guests of honor, esteemed Vice Chancellor, esteemed Vice Chancellor of the Bar Council of India University, Professor Venkat Rao, Dean, ex-Vice Chancellor, my good friend, Professor Vijay Kumar, Professor Manikyal Rao, Madhusudan Rao, and all others. I think I have nothing else to add, but I carry the impression that the purpose of establishing the national law universities, at least I could see, and I realized only 2 days before, that too at 1:30 a.m. That is, the credit goes to all the students, because I could never imagine students with so much enthusiasm at 1:30 a.m. and 2 a.m. because I came late, I entered, and the entire thing was daylight. And I could see the enthusiasm which I could not find anywhere during the last 60 years of my teaching career. That is, in fact, what the 5-year integrated course purpose is. The academia, the bar, and the bench, they must come together. They must constitute the trinity of justice. Friends, this is not justice of the court. This is not justice of this is the democratic justice, where we are all participants. I could see so much of enthusiasm, and this is how we see the students. They must also go into academics, and they must go not bar, bench, academics, and beyond. Just know I was a little bit too inspired. I think it's the last speaker who spoke about digital personalization, Article 21, digital extension of Article 21. And then this session started with Yada Yada Hi Dharmasya. I may add here, well, friends, we have been actually too much legalistic, but let us be a little bit more humanistic and also more intellectual ones. Mama buddhi astu magan mamaha. Mama buddhi astu magan mamaha. These are the words with which Mudra Rakshasa, written by Vishaka Datta, was started. The meaning of this is that creativity of the human being, bury all this technology, bury all this digitalization, bury artificial intelligence. The more artificially intelligent you become, naturally stupid. Naturally stupidity. But your intellect should never die. This is the moment you come with creativity. Just see how the drafting of the acts are done. We follow the Blackstonian logic. Sir, what is the title of our constitution? Article 393, the last article, this constitution may be called Constitution of India. Sir, such a document, we are celebrating 75 years. The other day, with a magnifying glass, I was looking, what is the title? I may say it's the Constitution of Pakistan. Sir, that too they say, why can't they say Article 1 itself, India, that is Bharat, is the United States. Why? This constitution is the Constitution of India. Can they not say this? As a Britishers are enacting the Constitution of India for us. Well, friends, why I am saying this, I am a little bit pained. You are, because you are, so much of, intellectuals, you are the intellectual storehouses. Simplify the language. Simplify, people can understand. And this is provisos and all these things. And even the orders given by the Supreme Court about governor, they are vague. They are announced in the Gazette. Are they acts? And now I am told recently, Income Tax Act is the toughest act passed by the Parliament in 1961. It's only now they found that at least there is simplicity. Otherwise, no, provisos are 100. And what is this text? There is nothing. This act may be called Income Tax Act. Finish. Provided that, provided. So, well, friends, my idea here is that you be more creative. And this creativity should be so much because it is for the people's constitution. It's the people you are working. This is what we call democratic dialogue. Or what we call political equality or legal equality. This should not be confined or monopolized only to the courts and lawyers. Let the law is meant for the common man. And you have, this parity, people to understand. Then only the courts need not be flooded with even the smallest things also. That is how we ourselves can solve the docket problem of the courts. So drafting is the most important aspect. You have, the finest brains here. You try to see in the simplest language, not that what we can see about Samuel Johnson's language. You know Samuel Johnson? भाई मैं शाम को शिकार जा रहा था, एक गंवार आया था, उसको एक ऐसा मारा था, वो नीचे गिर गया. When I was walking on an evening walk, a villager met me. I just slapped him, he fell down. When I was on my nocturnal perambulation, I met a rustic whose perpendicularity I made into horizontality. Sir, this is the legislative language. Out of 750 MPs, how many can understand? Let us be more realistic. Well, friends, I don't want to make this inaugural session. This is a valedictory session. So with these few words, your intellect shall be remembered forever for making the laws very clear. And they must be for the purpose of obedience, not for avoidance. Plain, simple, and certainty. And that will help these people to do justice for us, justice for all. Thank you very much. Thank you, Prakashji.
Thank you so much, sir. Thank you for your blessings. Before moving on further, Mr. Radhilal, sir, for your presence today, we are truly thankful and we wish to show our gratitude by felicitating you with a memento of Raja Bhoj, signifying your valor and wisdom in the field of law. I now kindly request our Vice Chancellor, sir, Professor Dr. S. Surya Prakash, to felicitate Mr. Radhilal Gupta. Thank you so much, sir. Moving further, The Indian Law Review Journal, which is the first law journal of NLIU Bhopal under the guidance of our Vice Chancellor, sir, that is Professor Dr. S. Surya Prakash, has been launched, which features insightful articles on contemporary issues. This journal aims to foster scholarly discourse and provide a platform for legal scholars to share their research. We hope this journal will serve as a valuable resource to students and academicians, and I kindly request the dignitaries on the dais to officially present the journal to the audience. Sir, I also like to invite Professor Dr. Sanjay Kumar Yadav to officially present the journal. Thank you so much. Today we also have with us Professor Dr. Raka Arya, a distinguished academician and a pillar of student welfare at NLIU. With a PhD from JNU, Professor Arya has played a pivotal role in shaping legal education and policy discourse. Serving as the Dean of Student Welfare and Faculty Advisor to the SBA, her dedication to research and advocacy is reflected in her extensive work on gender justice, human rights, and legal reforms, including her contributions to the Madhya Pradesh government's policy frameworks and national level committees. Beyond academia, she has been actively involved with Transparency International India and National Judicial Academy and the District Legal Aid Authority, delivering over 200 lectures and conducting numerous training programs. A mentor, a leader, and an inspiration to everyone. I now kindly invite her on stage for her closing remarks.
Thank you, Vaishnavi, and my greetings to you all. Honorable Justice Vanurmat ji, Honorable Justice D.K. Singh ji, Professor Venkat Rao, Professor Lakshminath ji, and Shri Radhilal ji, Chairman State Bar Council, Madhya Pradesh. My colleagues and those who are sitting in audience, the distinguished guests and the students, those who have come from outside, you all are of course welcome, and I would like to thank you all that you all spent time with us. I think आप सबको बहुत कुछ सीखने को मिला होगा. बस एक चीज़ जो आप लोग का रिक्वेस्ट था, नेक्स्ट टाइम इस तरह के इवेंट्स में हम ध्यान रखेंगे कि किसी ना किसी तरह से हमारा लैंग्वेज का कम्युनिकेशन आपके साथ इस बार से ज़्यादा अच्छा हो. कुछ नहीं होगा तो टेक्नोलॉजी है, हम टेक्नोलॉजी की मदद लेंगे तो उसको आपको हम संदेश ज़्यादा अच्छी तरह से दे पाएंगे. क्योंकि हम लोग वी आर ऑल्सो लिसनिंग आई थिंक in front of all of them, I am just like a small lamp. I can't show, जैसे कहते हैं दिया सूरज को लाइट नहीं दिखा सकता, तो I am just like that दिया only. But I would like to share something that is very important. This SBA, of course, has conceived this plan that they wanted to organize it. But Sir has been, I think, the brain behind it. The planning, the selection of speakers, and then after the discussion, everybody was picked up like this. And I think we all have benefited because of them, because for everyone he has said that they are, of course, gem of this particular legal field. As far as the theme is concerned, that is also conception of Sir. He was the one who conceived it. And we just played along and we just worked along with him as a team, because he is the patron and of course he's the father figure, and for me he is brother. So all that is there. So we all worked towards this particular theme to make this event that is a unique event in this event, because this will be the flagship program of SBA onward. Every year they are going to organize it. The only thing that I wanted to say about the theme that was happening, Lord, you have heard about bar and bench. I would like to speak beyond, because we are the one who are part of beyond. We are not bar, we are not bench, we are beyond. And my students also, they are still beyond. They are not, they have not joined anything yet. So they are also like that. So we have been a very, very learning, and I think every word was a nugget for all of us. It has created a kind of thirst in us that we don't want to leave it. We want to go on hearing. The only thing I can tell to every speaker that we can just, say some apologies to you that we could not give you the time that we should have given because it was a 2-day event. But then it has given us a thought that next time we'll give you more time so that, of course, we can benefit from your wisdom, experience, and whatever you have told us, we have learned a lot. And it was a very new experience for all of us because what we have all been used to. Because this is something what we were hearing about, and of course, the selection of theme that Sir has done has also, made us think about an institution. Generally, people don't talk. Because first of all, there is a hesitation about the institution itself because the kind of thing they are that people are very careful about their speeches and speak what they say about the institution. But this time, I think very freely we could do it. That we have discussed about the plus and minus and how the institution grew and what length it has reached and how much, it has to cover. So all this is there. I think we have been doing it successfully. And sir, yes, of course, we will bring out a souvenir out of all the speeches that has been given, and it will be shared with all the speakers, those who have come here. So, and also again, what has been said by Prachi, I'll say yes, of course. In India, we have a culture not to say goodbye. The culture is aate hain, to fir milenge. So this is something that we say. So once again, I would like to say that fir milenge, aate hain. Thank you so much that you are being part of this particular journey. Thank you so much.
Thank you so much, ma'am. As we come to the end of this conclave, we want to thank everyone who made it happen. To say a warm thank you, I invite Mr. Pushpendra Dikshit, Vice President of SBA, to the podium. Let's give him a warm welcome.
Honorable dignitaries, esteemed guests, respected faculty members, dear students and friends, good evening to all of you. As the curtain falls on the first NLIU SBA Law Conclave, I, Pushpendra Dikshit, Vice President of the Student Bar Association, would like to extend the vote of thanks on behalf of the SBA and the NLIU family. This conclave was not just another academic event. It was a heartfelt tribute to the Honorable Supreme Court of India as it completes 75 years. Through each session and every discussion, we were reminded of the importance of justice, truth, and dialogue in a thriving democracy. Further, we are truly honored to have been graced by some of the most distinguished members of the legal fraternity. The inaugural session of this event was graced by Honorable Justice Pankaj Mittal, Judge Supreme Court of India, and Justice Suresh Kumar Kaith, Chief Justice of Madhya Pradesh High Court and Chancellor of our university, and also Justice Vivek Agrawal, Judge Madhya Pradesh High Court. On the behalf of the SBA, I extend our sincere thanks to Honorable Justice Mr. S.R. Banurmat, former Chief Justice of High Court of Kerala, who blessed us as the chief guest of the valedictory ceremony. We are also deeply thankful to our guests of honor, Honorable Justice Mr. Dinesh Kumar Singh, Judge, High Court of Kerala, Mr. Radhilal Gupta, Chairman, State Bar Council of Madhya Pradesh, and former Assistant Solicitor General. Their presence, words of wisdom, and shared experiences brought great value and depth to this event. We are truly thankful for their time and contribution. We would also like to extend our gratitude to respected academicians, Professor Dr. A. Lakshmikant, Distinguished Professor Emeritus at NLIU Aurangabad, Professor R. Venkat Rao, Vice Chancellor, India International University of Legal Education and Research, Goa, and Professor V. Vijay Kumar, our former Vice Chancellor, for gracing the event as panelist and special guest for the valedictory ceremony. As the center of this success are the guiding lights who made it all possible. First and foremost, I would like to express our deepest gratitude to our Vice Chancellor, Professor Dr. S. Surya Prakash Sir. His constant support, wise counsel, and faith in the abilities of the students were vital in turning this vision into a reality. I also extend heartfelt thanks to our respected faculty in charge and Dean Student Welfare, Professor Dr. Raka Arya Ma'am, whose continuous guidance, encouragement, and mentorship helped us every step of this event. Her involvement gave us strength and clarity throughout the planning and execution of this event. We also take this opportunity to extend our sincere thanks to our Registrar, Mr. Vivek Bakshi Sir, and Deputy Registrar, Rohit Sharma Sir, whose timely approvals and smooth handling of all financial related matters ensured that there were no roadblocks in the planning and execution of this event. We would also like to extend a heartfelt thanks to Mr. Nipraj Bhati, former president of the Student Bar Association, whose visionary spark gave birth to the idea of organizing this law conclave. And now, to the true heroes of this event, the dedicated members of the Student Bar Association, my colleagues, SBA President Mr. Yaspal Jakar and Secretary Mr. Priyanshu Gupta, members of the core committee, and all our tireless volunteers. Their months of planning, sleepless nights, meticulous coordination, and sheer willpower have made this conclave not just possible, but exceptional. Every session that ran smoothly, every guest that was warmly welcomed, every detail that went unnoticed but was executed perfectly, it all stands as a testimony to their commitment. I would also take a moment to thank Pranay Bhaiya and the entire team for managing the convention center so efficiently. Last but not the least, a heartfelt thanks to all those students, faculty members, alumni, my dear friends who supported us at every stage of this journey. Your presence, encouragement, and good wishes meant the world to us. As we bring the curtain down on the first NLIU SBA Law Conclave, let us not see this as an end, but rather the beginning of a new tradition. With the blessings of our guests, our teachers, and with the support of our university students, we will definitely take this conclave to new heights in the successive editions. Thank you all for being a part of this remarkable event. We hope to see you again next year. Jai Hind, Jai Bharat.
Thank you so much, Pushpendra. I now kindly request everyone to please stand up for the national anthem. With that, we come to a close to the first NLIU SBA Law Conclave, and I kindly request the dignitaries to join us for high tea at the visitor room. Thank you so much.